That may I have a lordship's leave to mention a matter when according to your lordship's division bench at 1 p.m. of the circuit bench. When I had mentioned this matter at on 15th, lordship had indicated that this matter would be listed along with the listed matter in the Port Blair bench.
Yes.
But this matter has not been listed.
That is also a three-judge bench matter.
No, that's a division bench. It's an appeal from an
that was a mistake on my part because that three-judge bench cannot appear before that bench.
Yes,
it can only appear when I sit singly or something like that, or that particular division bench sits.
Yes.
Otherwise, it cannot be because that bench is only assigned.
No, of course. Then I'll come back and mention when your lordship takes up the division.
Yeah, that matter is to be heard by who else along with me?
There is whenever your lordship will take up the Port Blair bench, matters that is the Port Blair bench
section. That composition of the bench, that was the difficulty.
Yes, I do understand.
Whenever we'll take up Port Blair, any Port Blair matter comes, your matter will be given. Or even when you come back from the Jalpaiguri circuit, I'll be going there. Immediately after that, just have it mentioned and we'll put it on some day and take it.
I shall. Grateful.
My lord, may I be permitted?
Appellate side?
Appellate side and my lord.
Appellate side mention on the appellate side.
My lord,
no, not now. Yes, call on them. In view of the above discussions, no ground for recall of the order dated September 5, 2024, passed in such and such has been made out. Accordingly, CA 10 of 2025 is dismissed on contest, thereby sustaining the order sought to be recalled. No orders to cause urgent side.
And I'm praying for a I'm praying for a limited stay, but an interim order was continuing till
there's no scope of stay. The application has been dismissed. So if we'll record something
for a limited period,
after the order, after the above order is passed, learned counsel for the applicant seeks an order of stay. First of, however, since the recall application has been dismissed, there is no scope of any stay order. First of, accordingly, such prayer is refused.
Lordship, grateful.
It a letter করে দিতে হবে just opore letter লিখে দাও ওটা এর সঙ্গে পরে ঢুকে
Lord, I was caring for the official letter also on the last date. My name is disappearing.
Is not there?
No. I have given the list last time also.
এর নামটা আছে যদি আজকে জাজমেন্টে না থাকে ঢুকিয়ে দিতে বলে পল্লবকে তাহলে একটু দিয়ে দাও we will take care that it is today into this. Yes. Great. Thanks.
Great.
Thank you.
Lord, I appear for the petitioner, my lord.
Yes.
I was the respondent in the section 11. I was not present, my lord. An order was made appointing an arbitrator. Now, my lord, I know the limited scope of inquiry in a section 11, but I would want to place before your lordship two facts. One, that the application itself was not maintainable. Second, that my signature is forged. So when it's on the physical,
the other side is appearing. You are
I'm appearing. They are appearing, my lord. So, my lord, but I
signature of whom? The applicant,
of
petitioner.
Yes, applicant. The respondent in the section 11 is a
signature where?
On the contract which contains the arbitration agreement.
That has to be taken before.
No, my lord, there are authorities, my lord, which say that your lordships will be satisfied with the physical existence of an arbitration agreement. And if it's a forgery, other than fraud, your lordships' judgments are there in case of fraud, that the document has been signed, obtained by practicing fraud, etc. But where the signature itself is forged, then that...
Forgery and fraud, what is the...
No, my lord, there is a difference, my lord.
Very subtle.
There is a difference, my lord. But the fraud is, my lord, I have actively signed the document, but...
What's something that is pure forgery? I mean, pure fraud. I mean, practicing fraud upon the court at least.
Yes, my lord. So that is, my lord, that exists.
Fraud cannot be gone into by a section 11 court.
Beg your pardon?
Can fraud be gone into by a section 11 court, Mr. Thakkar?
Forgery can, not fraud.
We'll look into this.
There's a section 5 which I think they might oppose. There's a 255 days delay.
What is the cause shown there?
My lord, the cause is that, can we have the section 5, my lord? We came to learn only the section 21 notice was sent by DHL and admittedly not delivered. They sent an email after that, which I am disputing I have not received. They did serve the section 11 application by email. But at that time, my lord, there was some bereavement in the family. That email was omitted. We could not appear at the section 11 stage.
Bereavement in whose family?
My lord, in the director's family. This is a limited company. Although it's styled as a limited company, it's a very closely held limited company.
And then, if it went to the email of the company?
It went to the email. Malad, the section 11
They must have taken charge of that.
Section 11 application was served. Malad, there was a bereavement in the close family of the director. We filed this
There's
recall.
only one director, cannot be.
No, it's a family held company. Malad. Closely held family company. Malad.
So it's easier for us then.
No, Malad. But Malad, we came immediately after receiving notice from the learned arbitrator of the arbitration commenced 6 months after your lordship made the order. The first sitting in
That's a post facto.
that's a post facto thing, but that is my Malad, that 6 months delay is explained by that Malad, that I was. But if your lordship goes by the suit logic, Malad, then of course
Section 5 is.
there are serious grounds, Malad, on merit. Otherwise, the section 11 application, Malad, was filed. It has to be filed 30 days after the notice.
Yes.
After 21 notice, ex facie filed within 27 or 23 days. So that's on the ground of
What do you say to the Section 5?
Lordship, we are opposing the Section 5. Lordship, there's one fact I would like to bring to my Lord's notice. They are
Mr. Thakur, we are just first hearing the Section 5.
Please,
Yes.
Lordship, they are contesting in the arbitration proceeding. What they are really challenging is the existence and validity of the arbitration agreement. They have filed a statement of defense in that arbitration proceeding. They have missed the bus to file a Section 16. And after they have filed a statement of defense, they have come before this court asking for recall.
So now that should not be reopened. I mean,
Yes.
it can be taken up by the arbitrator.
Yes, my Lord.
That is on the forgery ground.
On the forgery ground. They have filed a statement of defense. In the statement of defense, they have taken this point.
What about the Section 5? I mean, what is your opposition? What is your ground of opposition? There's a
Lordship, the
family
ground-
bereavement, they say. How
Lordship,
many directors in total, Mr. Thakur?
four directors, Malad.
So all of the same family.
All same family. Malad,
Who died? How are they related?
Malad, I don't know, some bereavement in the family, that is what
Ah.
is written, Malad. Malad, kindly, Malad. Malad, we've not filed any defense. Kindly see the minutes of the arbitral proceedings which are annexed to my recalling application, please.
Recall is GA2 or
Recalling is GA2. Recalling is GA2. GA1 is the
Section 5?
GA1.
Or the other way around?
No, it is,
Maybe the other.
number is same in everywhere.
Yes, there's no indication in your caption, Mr. Thakur.
Yes.
It should be put in the caption.
GA1 is a section 5, Malad. GA1 is a
Look into
section.
the just prayer.
GA1 is a
Yes,
section.
one is one.
1 is section 5.
255 days, I mean, after you participate in the
No,
arbitration.
I did not. Kindly see the minutes. The minutes are there of the arbitration. There's no participation as such.
Which page?
Kindly have page.
They filed a statement of defense, they say.
No. GA2.
Lordship, I have a copy.
I'm not. Kindly see annexure page 161 onwards, please, Malad. Volume 2.
Yes.
Kindly see. This is the
Somebody
Second
represented the
second
respondent.
meeting. Malad, the litigant came inside. One of the directors came. Harsh Shah was the director. Kindly see. He placed the fact that. Kindly see D. No notice with regard to filing of the section 11 has been served. Present arbitral systemic fraud. Arbitrator has been requested.
The notice has been served, Section 5, Section 11.
Beg your pardon, Malad?
Notice has been served, you say, Section
No,
11.
Malad, section 21 notice was not
No,
served. The
here it
11.
says Section 11 was not served.
No,
D,
section
D.
11, we came to learn later that we checked our emails, we found that it was, the section 11 was served by an email sent from the advocate on record. So, Malad, that name, because of the name,
Before the arbitrator in B, you have stated that no notice with regard to Section 11
no,
was.
this is factually incorrect because when I went back, I retrieved it. I found that yes, the section 11, not the notice of the 11 application was given. This is a factually incorrect submission, which I've admitted, Malad, on oath, that this was.
You say that you have not filed your response, statement of defense before the arbitrator.
No.
But they have a copy of it, Mr. Thakur. Please take appropriate instruction. You can
No,
give a
my
copy.
learned friend is
Should have
not
extra copies.
He's not appearing in the. He's not.
Who has filed it? Please check up. It's only one company, one respondent.
Kindly have a look, Malad. I don't know, Malad, whether your lordship will treat this as a reply. This, my learned friend is also not aware of. Because I asked him specifically, what have you done in the arbitration? He says, I am not briefed.
Obviously, if you are ever then.
He says, he's not briefed in the arbitration. The litigant comes himself from Ahmedabad and does it.
Denies all the claim on the merits. On merits, Mr. Thakur also. We'll take note of this, we'll keep this on record. But you take instruction, we can give you time to take instruction on this.
Kindly give me time. I'll take it.
Maybe be given
This
Give
has
them a copy. Have you got extra copies? Give them a copy. I'll record something on that. and give them time to take instruction on this.
Lordship, can we also file an affidavit?
Well,
Bringing on
to the
record
section
all-
5 then.
To the section 5 and to the main application as well, we'll bring on record all.
If you direct you to file opposition to the main application, the difficulty is very well. I'll make it clear in my order. I'll direct you to file opposition to both, reply to both.
Yes.
But I'll make it clear that direction regarding response to the main application does not mean that the
Yes.
bill has been con.
Yes. This will only expedite the hearing on the next date. Yes.
Right, for that only.
Grateful.
Right. Learned senior counsel appearing for the petitioner, comma, while moving the application for condonation of delay, comma, seeks to place reliance on certain papers annexed to the main recall application. Full stop, next para. Learned counsel appearing for the claimant stroke respondent in the present applications submits that preliminary reply to the statement of claim has been given by the respondent and, comma, as such, comma, the respondent stroke present applicant has already participated in the arbitral proceeding pursuant to the order passed under section 11 of the Arbitration and Conciliation Act 1996, comma, which is sought to be recalled. Full stop, next para. A copy of the said preliminary reply is handed over in court. Full stop. A copy thereof is also circulated to learned senior counsel appearing for the applicant before this court. Full stop, next para. On the prayer of the claimant stroke respondent, comma, the claimant stroke respondent is directed to file its affidavit in opposition to both GA Com 1 of 2025 as well as GA Com 2 of 2025 within a fortnight. Within a fortnight from the date, reply, if any, shall be filed within a week thereafter. Both the applications shall be listed together on August 22, 2025. Full stop. It is made clear that the direction for filing affidavits with regard to GA Com 2 of 2025 shall not be construed as the condonation application being disposed of. First. Thank you.
Grateful, man.
We are keeping this on record, but you have got a copy, Mr. Thakur?
Yes, I've got it.
Not to the usual practices.
No, that's a review. Oh, no.
The review is
Oh, I'm gonna respond.
that is the usual practice regarding this one. We have a Port Blair bench at 1, Mr. Mitra. So
Kindly,
this bench will sit up to 1.
this matter will go on. So if in case Lordship wants to relieve others,
We can.
Lordship.
So you are sure it will not stop me doing or something like
sure, I will, without being
that? Mr.
able
Basu is very happy. So very well, other matters are released. All other matters are released. Original side.
this is the matter the Lordship has heard at length.
Yes.
I will cover two aspects really, which one of them is partly overlapping, partly pouring new wine in old bottle or old wine in new bottle, whichever we may put it. That is that 8.3 and that is that 8.3, 8.2, that's a cap. I will,
Mr. Mitra, may I know which respondent you are
number
referring?
6, Bala.
Yes.
The
8.3.
cap on damages.
Right.
But I will be addressing from the point of 8.3 being an exclusionary clause. Excluding all other rights are excluded. So once it's exclusionary, the arbitrator's jurisdiction is ousted. Say, for example, if the agreement says that arbitrator that interest only claim is this, exclusive of all others, exclusionary from that angle. Yes. And the other aspect is, of course, on damages, on proof of damages. For loss of profit, I would say they have not come anywhere close to proving the damages for loss of profit, where a high test is required and where at the 34th stage also.
That was also argued by Mr. Thakur, but you can, I mean,
Yes, he had argued with
it was touched by Mr. Thakur, loss of profits.
But I'm told that on proof of damages, Mr. Thakkar had
Yes.
not really argued. Lordship will stop me if I.
No, when you not stop him, Mr. Mitra, you make your argument.
Lordship, kindly come straight away to the my first point, which I should get over quickly, is the 8.32, and Lordship kindly comes to.
And let me kindly take the convenience compilation, volume 1A.
I mean, that's
1A.
8.
1 does not have any A.
Wait, no, then 1.
1, oh, yes. 2 has A and B.
Yes, I apologize. Volume 1.
27, the clause should be there.
8.1.
Running change 27, clause 82.
Yes, this is 1, volume 1. Right. Thank you, Mr. Mohan. This is 8.2. You want to rely on 8.1?
8.1 briefly.
8.1, yes. 26 is 8.1.
Yes. 8.1. 8.1.1. That is, this is the clause which is applicable to us. I am a seller. I am not a promoter. Subject to completion of NR closing, IR closing, IR cash closing or CS closing, whichever is applicable in connection with the relevant seller, each of the sellers agree that they shall severally and not jointly indemnify and hold harmless the acquirer of any losses incurred by the acquirer directly, including losses relating to claim by a third party. So direct loss of profit is an indirect loss, which arises out of or result from or are connected with a breach of the relevant seller or a breach of the relevant seller of its seller warranties. The only clause which may come under this closely is clause 12, which I shall place later. And B, any claim relating to or defect in the ownership of the seller transfer shares of the seller or an encumbrance thereon in respect of the period prior to the NR closing. This does not apply to us. There is no case of the shares being defective in ownership. So this will then take me to clause 8.2. Sorry, 8.1.2. 8.1.2, partly it covers me.
Yes.
It doesn't cover me too. It's 8.1.2 is only promoter and the target company.
This is
So,
promoter, right.
so I am liable under 8.2. So seller indemnification procedure 8.2, 8.1.2 applies to promoter
Yes, right.
and the target company. So it doesn't apply to me.
No.
8.2 applies to me. Seller's indemnification procedure. If the acquirer suffers a loss which is indemnifiable by the seller or the promoter, I am on the seller under 8.1, each an indemnifying party, then the acquirer shall issue a written notice to the indemnifying party describing in reasonable detail the losses suffered by the acquirer. Not given. Indemnifying party shall have a period of 30 days from the receipt of an indemnification notice to object to such indemnification notice or any part thereof if the indemnifying party notifies the acquirer of its objection to the matter set forth in the indemnification notice, and if the acquirer and the indemnifying party are unable to mutually resolve the matter within 30 days of the objections being notified. acquirer or the indemnifying party may refer the dispute to arbitration.
You
So
say no notice was given at all?
No, no,
No
no,
indemnification?
no 8.2 notice was given at all. Because there's no other side.
Lordship, I am for the award holder. No worries.
Thank you. Now, all this takes us to 8.3.2. Sorry, 8.3, 8.3, 8.3. That is the next page.
Yes.
It is clarified that notwithstanding anything in this agreement, the indemnifying party's obligations to indemnify the acquirer under 8.1 shall be subject to the following limitations. The maximum aggregate liability of each of the NR sellers.
You are NR or otherwise?
I am. We are not an NR seller.
So you are 8.3.2.
I am 8.3.2. The maximum aggregate liability of each seller, which includes me here, including the promoter, towards the acquirer, shall not exceed 25% of his or her respective cash consideration amount realized from the acquirer in accordance with the agreement. So that's the maximum that comes to less than $1 million for me. That 25%, $654,000 to be precise. Anyway, that your lordship is not, possibly I will not require my lordship to go into the amount, but and finally,
3.2 was argued.
this was argued. So now I am on 8.7. Notwithstanding anything contained in, it is clarified that the indemnification rights of the acquirer, that is 8.2, under this agreement, are the exclusive monetary remedies. I am on the exclusive monetary remedies of the acquirer for any losses or damages based upon, arising out of, or otherwise in respect of the matters not set forth under this agreement. I am saying this is exclusive, means it excludes all others. And the arbitrator's jurisdiction automatically is ousted for any other claim. Since this is exclusive monetary remedy. This is apart from the rewriting of the contract, which Thakkar, Bachawat, they have all argued. Sangyong.
Damages for loss of profits, doesn't it come within arising out of?
Yes, it exactly. So that's what I'm saying. Notwithstanding anything contained, it is clarified that the indemnification rights of the acquired is agreement
Not based upon maybe, but arising out of.
For any loss, damages arising out of course. So that's profit or loss of profit.
Yes.
So then, kindly see the first line of 8.7. Notwithstanding anything contained in this agreement, is clarified that the indemnification rights of the acquirer under this agreement are the exclusive monetary remedy. So indemnity right is only under 8.2. So that's why I'm saying loss of profit, lordship arising out of contract is also loss of profit.
So then, indemnification rights
under
are
this
the exclusive, yes. It's restricted to indemnification rights.
Under this agreement,
that does not, the ball is not set in motion because the notice is not there.
That is my first.
If the notice was there, then this would come in.
Then this would come in. Then in that case,
then they could have asked for this.
Then they would have invoked 8.7 and said, you indemnify me for the loss of profit. To which I would have answered that the indemnification rights of the acquirer under this agreement are the exclusive. So under this agreement, the only indemnification right is 8.2. If your lordship now goes back, that's an indemnification right. That's the only indemnification right which is under 8.2, and then that takes us to 8.3.
25% cap, that applies, no doubt.
That
That definitely applies.
So that would be the indemnification, right? But
So two rungs on which you prevent him. One is no notice was given, indemnification notice. Secondly, 25% cap.
even if it was given, that
Then
would
that
be a
would
cap,
be restricted to
and
that.
that would exclusion would exclude all other monetary.
That 25% would come in your case to about 1 million.
$654,000. Though I will. This is a figure written in my personal note.
So less than 1 million.
Less than less
What
than
has
1
been
million.
given here? What has been awarded?
Awarded, I will just 100 and no.
107 or
Apportion
something
share
like
bolo. Apportion share ta bolo.
in the range of 100 something.
Yes, apportion share of mine is no, not that much. Let's be clear. 3.2 million too. It is 3.2 million.
That would be beyond the 25% cap.
Well beyond. 3.2 million plus
1.1.
plus 1.18. I mean, that is well
That's beyond the 25% cap. Even if the indemnification notice was given.
Primary and additional.
So well beyond. So on this, my first point is no notice. So without 8.2, you can't come to either 8.3 or 8.7. Mine is 8.3.2. Mine is 8.1A is my alleged breach. 8.1.1A at internal page 25. That takes me to clause 8.2, giving me a right to receive a notice. And
Right.
then the following: if it can't be resolved, then I am liable for indemnification under 8.3.2.
Right.
Which has a cap, and 8.7 is omnibus, applies to all of them. That is the exclusive monetary remedy. That what you are getting under 8.
But damages for loss of profits comes within that exclusive.
Of course, because
So
there is
therefore, that exclusionary argument, it's not exactly an exclusionary argument. It's a lack of notice argument
lack of notice
and 25% cap argument.
20% cap. So
In that sense, excluded.
that sense,
that-
all others are excluded. Any other
8.7 does not help you much in the sense that this arising out of may cover.
may cover. Loss of profit will be covered, no doubt. Loss of profit, I shall approach it with the cap. Loss of profit with the cap.
And
Now-
prior notice.
Now the loss of profit, I shall approach it separately by showing that there's no proof.
Yes, that's a different argument.
That is something really I am looking forward more to argue that, because that has not been possibly.
No, that was probably awarded on the basis of conjectures and surmises. Mr. Thakkar argued that what could have been done if you had followed that. That was argued at length.
Briefly, McKinsey apparently gave a report to the holding company, Inc., which report was for all their prospects, for all their subsidiaries, the entire group.
It would depend on many ifs. If that was adopted, and then it was seen that the profit margins indicated there would come, and also it was on the basis of some approach to the ICICI Bank. These were argued,
So,
and both of you, the people on both sides of you, are colluding against you to repeat the argument.
I'm not.
You are not there. Then on your left,
on my left, because I was
also not present.
you are not. Sorry, I withdraw that.
we were not briefed.
Right side is withdrawn. You're right.
because he's the only person lucky to get briefed for all the arguments.
Yes.
None of the
He's so lucky that he has forgotten what has been argued initially. This is argued at length with you can argue, but
because
now we have no other option because we have released other matters. So you have to.
because here this will really, the arbitrator has also said the imponderables.
No, you can in a nutshell make your argument.
Yeah.
I mean, no difficult.
Because this was dependent on ICICI.
But at the time of making your written notes of arguments, please please take care that it's not there's no overlap. Otherwise, it will be very difficult for me.
There should be actually two written notes.
And we don't have helping hands like you, so it will be very difficult for me to.
There should
If
be
you
one-
overlap arguments,
Who's the
in your written notes, please just collate.
There should be one target company's written notes. Is it in NRSL and no one?
There will be some overlapping arguments, But you can just, I mean, do whatever, refer to
Well,
the.
I would request my solicitor to have two notes. One is for the target company,
Right.
that is one category, this one number one, and the other for all the,
Still, there might be some overlap.
all the cell is one note.
One note,
if
but
we can
still
give-
there may be overlap in arguments. I mean, there
So
would be
if it's-
some common arguments.
If it's
If that
one
is to
note-
just indicate as one.
If it's one note,
Right.
then there can be no. I would request that, but then of course I had to. That if it can be one note, that'll be that'll be useful. Otherwise, lordship to go
It will
through
take
each.
more time.
And also not
unnecessary.
fair on the court without. I can't argue without juniors next to me, and you have to write your judgment without anyone's. It's not fair. And my junior is very keen that I should place 14.2.2, which nobody else has placed. That is internal page 33.
Yes,
Take it
not,
as Mr.
not
Dhruv,
marked.
Dhruv Chadda's argument.
Not marked.
Huh? No.
If it is not marked here, then
Take it as Mr. Chadda's argument being made by me. 14.2.2.
yes.
In the event of any party asserts, any party asserts that there exists an arbitrable dispute, such party shall deliver a written notice to each other party involved therein. That's apart from 8.2.
Yes.
8.2, I'm saying it's very important. And requesting a meeting to attempt to resolve the matter. If no such resolution is reached within 30 days after such delivery of such notice, the party delivering such notice of arbitrable dispute may, within 45 days after delivery of such notice, commence arbitration hereafter by delivering to each other party involved therein a notice of arbitration and by filing a copy of such notice of arbitration with the ICA. Such notice of arbitration shall specify the matters as to which arbitration is sought, the nature of any arbitrable dispute, and the claims of each party to the arbitration and any other matters required by the rules and procedure of the ICA.
Mr. Mitra, I'll be
was not
seeking a clarification on one point. Now, you agreed, both of you agreed that Indian law would apply. There is no doubt that substantive Indian law would apply, contract and everything else. But then would the domestic arbitration procedure also apply?
So that is
I have my doubts on that.
what I'm
Because it's an
hinging-
international arbitration. After all, these rules are there, governed by the.
so that is what I'm hinging on. Because if it's Indian substantive law, this is a procedure.
Substantive law, no difficulty, but procedural law, how far it is applicable? This is on as per the clause.
This is
Clauses are
procedural
definitely-
law.
Clause is definitely binding.
No, but this is apart from that. This is a procedural law. So in the Indian substantive law, Lordship knows very well. Lordship will deliver that these two-tier once resolution and then you go. That is not mandatory. That can be culled out from the conduct that there would have been no purpose could have been achieved. But that's Indian law, substantive law. But this is a pure procedural law. This is not substantive. There's nothing to do with the substance of this. So here, this will be the law of that land, and there is no finding of the award. And the award arbitrators have gone wrong in relying upon Indian substantive law. That's what I will.
The substantive law, you agreed?
Yes, but this 14.2.2 won't be governed by substantive law of India.
No.
So
But
that's why
14.2.2 is a clause of the contract itself.
contract, and that's purely procedure. That nothing to do with the substance of the matter.
That emanates from the contract.
Contract.
Even if it's procedure but provided in the contract
has
itself,
to
it's
be followed.
contractual.
No, I must say, Lordship, if it was procedure, if this kind of a clause was there in Indian domestic arbitration, and this was not followed.
No, you say that even if there is some procedural aspect of a clause of the agreement itself, then also it would not be followed.
No, but then, Lordship,
It would be contractual.
Section 11 cases, there are judgments where the
Yes.
court has found that I will not send them back to give a notice for mediation and then
Yes, yes.
because I see that there is no possibility of settlement.
That's on a different footing. 11, we are much more liberal in a sense. I mean,
Yes.
our scope is very limited.
Because the only now to look at the
Now, yes.
so but that is the only thing, but that will be the Indian law which will not apply here. That Indian what Indian courts have done in many cases, some cases otherwise also, many cases that Section 11 stage, this is not strictly followed, will not be the law applicable to the arbitrators.
But this is not, yes, right. This is not the section.
This will not be applicable.
No
So
question of
this
that.
is the only. Otherwise, had this been Section 11, I would have been hesitant to argue this.
Section 11, very
But this being a purely procedural law, or procedural aspect, prescribed by contract in a country where there is no such law which has been relied upon. So the substantive law of Section 11 in India will not be at all relevant for the purpose.
Section 11 is not German here at all.
Yes, that's the whole point. And this is the basis where the learned
But
arbitrators
from this 14.2.2 is binding on both of you.
that is what, but that has also not been followed. That has also not been followed. So 8.2 and 14.2.2 both have not been followed in our case, and the three.
No notice was given to you at all on this.
No. I will show. I will show that.
Some
This-
notice was given
This
to
is
you.
1 day, 1 day's notice, 1 day's notice, 1 day. And not in terms of, you can only give me 1 minute. Just take.
So this 30 days period was not left given.
Not at all. Or should kindly, yes. The notice that was given to us was was on 4th November.
You can just refer to the volume. I'll take a note here.
24th October 2022. It is at page page 1 of second compilation. Second compilation. 2A is the compilation called 2A.
2A.
2A page 1.
Very
What do you call it?
24th October 22.
Yes, madam. Award and bullet.
Yes, 14.2.2.
This is 24th of October 2020. Date chronology দিয়েছেন? Date chronology দিয়েছে দেখি। On
When was the reference? Within
the reference was made, I think, 20
Very next day, emergency arbitration.
emergency would be different. 25th of October, there was an emergency arbitration notice,
And 4th November is request for.
and
So if you see
well, Lordship,
page
this
45.
this is how I would like to put it. Emergency arbitration is not commencement of reference.
Para 45.
Then that defeats your argument that 30 days was not given.
No, but then the reference was thereafter made by them separately on 4th November.
4th November.
That's also.
This is what I am.
So if you show from para 41 page 20.
So, well, I am on this aspect. If emergency arbitration was the end of the matter, then this, but here there's a separate reference commencement. So, emergency part, there is a logic in the
You can, if you can just give me the page numbers. Or
Here, kindly see the award. Can I see the award?
Ah,
There
very
is
good.
in the award, page 24, internal page 24 of the award. This is briefly stated. That's it.
24 years.
Page 243. Internal page. Internal 243. Paragraph 41. The parties through their counsel had exchanged letters and emails communicated with the tribunal. Dr. Kelly, come to 42. The claimant had filed an application for emergency measures pursuant to Article 29 and Appendix 5 of the ICC rules. The EA application was filed on 25th October against the entity and individuals comprising the group A respondents. In response to EA, ICC appointed an emergency arbitrator on 27th.
Para 45 says 4th November is that.
Yes. So I am on this 4th November.
All right.
And this point was also taken by Junior para 39. Para 39 records this point was taken.
Yes, yes.
And this has been dealt with at paragraph 242 242 to 244. Internal page 109 and 10. Internal page 109. The respondents group A argued that as a yes, 109 of internal.
Yes.
The respondents group A argued that as a consequence of clause 14.2.2 of the original SPA, a party can only commence the procedure. 243, the claimant asserts that the pre-arbitrate negotiations are not mandatory under Indian law, particularly where such negotiations would be futile. And these footnote, these are all section 11 cases. Negotiations would have been futile in this case as a result of the particular animosity between the parties reflected in the criminal proceedings started by respondents group A against the claimant and his officers. Regarding the last point, the claimant states, 25th October, it sent its notice of arbitration. Arbitral dispute to the respondent stating inter alia that Uphealth and his representatives shall make themselves available to meet with representatives of local to establish a constructive dialogue to find a mutually acceptable solution. We had said. Dr. Azim responded on behalf of the company on 2nd November, inter alia, expressing.
Para 244, it also says 45 days has elapsed between the notice of arbitral dispute and its amended request.
But that is. So the urgency part was gone with the emergency award also being delivered.
So amended request date cannot be the determinant. The first request obviously is.
So this is my first point, 14.2.2, and then 8.2, that's also, that notice not given, so they were not entitled to claim the, so there are two things. One, they could not commence the reference, and 8.2 is on the substantive matter that they can't claim their damages because 8.2. That is absolutely mandatory, that there is no Indian law which also says that this can be dispensed with. If the contract requires, and also read with 8.7 and 8.3, that this is exclusive procedure, exclusive monetary remedies as per the in terms of this agreement.
Plus, there is another aspect to it that the tribunal says it's not mandatory under Indian law. Even if you took it to be not mandatory, and we say that is procedural law is also applicable, then also this right is contractual. Apparently, this is not a procedure derived from law, contractual rights. So emanates from the contract itself. Very well. We'll think on that.
The point of we'll come back to it later.
I will not say something which I have not seen earlier. I have enough to cover more than one day, so.
Yes.
Apart from now coming to 8.2 and 8.1, 2, and 3 and 7, that is from the award. Apart from Sangyong, which has been placed and which encapsulates the entire Indian law perfectly, I would like to show, my lord, on that exclusion clause would exclude the arbitrator's jurisdiction to decide, apart from rewriting the contract. That exclusion will exclude the arbitrator's jurisdiction. Am I down 96 down? No, 99, 9S is the exclusive means barred to claims beyond 8.2, 8.1, read with 8.3, as well as not in compliance with 8.2. So that will exclude the arbitrator's jurisdiction because the arbitrator is bound by the terms of the agreement. Court may still have certain inherent powers which the arbitrator will not be having. Worship, the first judgment I cite is 1999, 9 SCC 283. এটা কি exclusion ছিল বলতো এটাকে? এখানে কি exclusion ছিল? চট করে দেখে আমার মনে পড়ছে না। What was this? Paragraph 22. What was excluded? Yes, no, that's quoted in paragraph 22 itself. Page 300.
Yes.
Further, in the present case, there is no question of interpretation of clauses 17 and 18, as the said clauses are so clear and unambiguous that they do not require interpretation. Clause 17. It is both in positive and negative terms by providing that the contractor shall be paid rates as fixed and he shall not be entitled to extra payment or further payment for any ground whatsoever except as mentioned therein. The rates agreed were firm, fixed and binding, irrespective of any fall or rise in the cost of the work covered by the contract or for any other reason or any ground whatsoever. It is specifically agreed that the contractor will not be entitled or justified in raising any claim or dispute because of increase in cost of expenses on any ground whatsoever. By ignoring the said term, the arbitrator has traveled beyond his jurisdiction as his existence depends upon the argument and his function is to act within the limits of the said agreement.
This was a domestic arbitration,
Domestic
but section 48 and section 34 overlap on that.
And then
Paragraph 17 and 18 was 18 this clause set out.
and paragraph 17 and 18 where the clauses set out.
Need not. Para 22 gives an idea.
And then
Rates
read
were
with,
firm and
and
the
read
other
with
thing.
paragraphs 22, 23 and then 45.
23 also the first two sentences. Yes.
And then the conclusion is 45.
Very.
This will also cover my clause 14 point. And para 45. Page 311, para 45.
Yes.
So this could come
Arbitration Act. Yes.
under section 48. 48 1C. This
Yes.
is
48 apart from patent illegality, probably everything is there. Almost everything is there.
because 34 2
Hmm.
2A Roman 4 is same as 48C.
So when enforcement of a foreign award comes, we
Have to see
abide by
whether-
your own law regarding
Because
the parameters of appeal are applied.
So whether it may be enforced in US, where the law may be permitting this, but our Indian law will not permit. Actually, yes. And one more judgment on this proposition, 2007, 4 SCC, page 693. George said. अच्छा, आज सेट के दाओ. Closes that page. Same thing. Paragraphs, I will not, 11 to 19.
Yes. These are settled principles, Mr. Mitri. We need not further
So,
repeat
but
that.
now, may I move on to the section or to the assessment of loss? Because I was told Lordship was not, it was not, the Unibro's judgment was not cited.
I don't
The
recollect it
Supreme
being
Court.
cited. No.
Without that assessment of loss of profit can never be complete, because that's the recent Supreme Court judgment which has captured all the laws and how to assess loss. In a 34 case, an award was set aside on that ground. Similarly, I will place that judgment first, and then I shall come to
Yes.
some of the things which your Lordship has already considered.
Better.
Unibro's to now. Not yet report. Sure, the report হয়নি এখনো?
না, এরকমই আছে এটা। আমি দেখে নিচ্ছি একবার, এরকমই আছে।
I downloaded very recently.
You downloaded in October 24.
This is paragraph 16 on it's on loss of profit. Even our Bartley boy judge Lordship must have seen this ipse dixit of the arbitrator awarding damages, and then the court saying that I can't look into has been not followed. That's not the law, and the courts for damages part not being properly assessed, awards have been set aside. This is on loss of profit. To support a claim for loss of profit arising from a delayed contract or missed opportunity, we are on missed opportunities from other available contract that the applicant could have earned elsewhere.
Probably
By-
section 73 considerations also come in, because that is substantive law, contract act.
It's absolute. And there nobody can claim breach and assess his own damages and say, you can't get a decree in your favor, pass a decree in your favor. It's hard. May I just place paragraph 16 and 19?
Yes.
Just to brush up my memory also, to support a claim for loss of profit arising from a delayed contract or missed opportunity from other available contracts, as this is their case, that the appellant could have earned elsewhere by taking up any, it becomes imperative for the claimant to substantiate the presence of a viable opportunity through compelling evidence. There can't be a windfall. This evidence should convincingly demonstrate that had the contract been executed promptly, the contractor could have secured supplementary profits utilizing its resources, existing resources. This is subject to 8.1, where it says only direct losses. This is an indirect loss. Clause 8.1 says only direct losses. Now kindly come to paragraph 17. One might ask, what would be the nature and quality of such evidence? In our opinion, it will be contingent upon the facts and circumstances of the case. However, it may generally include independent contemporaneous evidence, such as other potential projects that the contractor had in the pipeline, or not a report that could have been undertaken if not for the delays. The total number of tendering opportunities that the contractor received and declined owing to the prolongation of the contract, financial statements, or any clauses in the contract related to delays, extension of time, and compensation for loss of profit. While this list is not exhaustive and may include any other piece of evidence that the court may find relevant, what is cut and dried is that in judging a claim to a loss of profit, the court may not make a guess in the dark. Here, this is absolutely what he has done. The credibility of the evidence, therefore, is the evidence of the credibility of such claim. Hudson's formula, while attained acceptability and is well understood in trade, does not, however, apply in vacuum. Here, of course, Hudson's formula has not been applied, so I am not placing paragraph 18. I'm coming straight away to paragraph 19. The law as it should stand, thus, is that for claims related to loss of profit, profitability, or opportunities to succeed, one would be required to establish the following conditions. First, there was a delay in completion. Second, such delay is attributable to the claimant. Third, the claimant's status as an established contractor. Now, fourth onwards is where it's credible evidence to substantiate the claim of loss of profitability. On perusal of the records, we are satisfied that the fourth condition, namely, the evidence to substantiate the claim of loss of profitability remains unfulfilled in the present case. Yes, Hudson's and other formula apply generally.
Hudson's formula, it has been recorded here that
Yes.
it does not apply in a vacuum.
But here, no formula. Take it.
Para 18, if he's saying para 18, I've read it.
He's
Just now I read it.
He's so very well ready. But I admire because without him, none of the
That's matching.
can
No,
can
no.
argue without his contribution.
No.
Lordship. Now this will take me to straight away to what is the evidence here. To what is the evidence here on loss of profit. Lordship, can I tell you, Lordship, briefly. There is a Professor Len who says that I am relying upon a report of McKinsey. McKinsey's report not placed, not proved. Placed, of course, as part of the McKinsey's report contemplates with this investment, if 20 to 23 million dollars in cash is
Many ifs.
invested,
At least 3 layers of ifs. Yes.
then only you can earn profit. So no evidence direct from the owner of the company that I had this contract, which I could have entered. And then the arbitrators themselves have held that there's a, depending on additional financing debt being available from ICICI Bank. There is no evidence whatsoever that ICICI Bank had sanctioned or intended to sanction
Only one meeting with ICICI.
oral. That's after the evidences or after the argument, one meeting that anybody can say. Like today, I can say that I'll take over a company, I'll invest 1 lakh of rupees. So that didn't happen. So now, had I invested, had I
There
taken
was
over,
probably no in principle approval also from the ICICI.
nothing, not
That
a
was
single
argued.
document.
That was argued. Yes.
Now, here I will show a few paragraphs from the award. Computation of the claim, because causation everyone has shown extensively. I'm only on the computation part. Is from internal page 159 up to internal page 169, 10 pages, paragraphs 363 to 383. I am leaving aside the $1.7 million cap part.
The paragraphs, please repeat.
Paragraphs 363 to 383. 20 paragraphs is on loss suffered. Now, what is relevant for my case,
This was actually placed in extenso, but you can still.
then if I want to make it brief, then I am very interested in placing para 374. However, there remain several imponderables in the assessment of damages. A. Professor Len treats the lack of actual control as a permanent lack of actual. On this score, I am not joining issue. B. It is unclear whether the claimant would have been able to secure additional debt financing from ICICI. That whole thing, because it's not that they have not shown that they have the money to do it. What conditions would have been attached to the debt financing? What implications these factors may have had on the credibility, on the company's ability to implement the McKinsey recommendation? Professor Len has not carried out a robust but-for analysis. In these circumstances, the relief to be granted has to be tempered to take into account these considerations. It can't be granted because just because these are not proved, I will guess. That is not the law. Now, what the arbitrator has done thereafter is paragraph 377. While the above considerations might also raise questions whether the claimant would have been able to fully implement all of the McKinsey recommendations and achieve the most optimistic scenario, there is no cogent evidence to show claimant would have been unable to implement most or at least essential components of McKinsey recommendation. This precludes the adoption of the lowest protection. It is pertinent that the claimant as well as respondents consider the McKinsey recommendation to be important for the growth of the company. This is before the takeover. The claimant has shown that it has been seriously committed to continue the work of Glocal, and furthermore had already invested in Glocal under the original SPA at $4 million and engaged services of McKinsey to improve Glocal's operations. The tribunal notes that the claimant had invested and incurred sum of 7.2 under the SPA to procure shares. Procure sharing has nothing to do with it, because procuring share, the money comes to me, Mr. Damodaran, so and so forth, under the SPA to procure shares to pay off debts and fees. So it's all clubbed together. Despite this, it was unable to exercise its contractual rights to have oversight over the company and recoup any returns from its investments. It is thus more than likely that the claimant would have followed through to implement some or most of the McKinsey's recommendation. More than recommended, but where is the money to implement those recommendations? Where were those projects had it not been obstructed? In the circumstances, in addition to the tribunal's orders, which would result in the claimant receiving actual control of the company, as the primary damage, the tribunal awards the claimants have $29.5 million primary damages. The sum is representative of the damages already suffered by the claimant by being deprived of actual control from the date of loss to the date of this award. The said sum, he has invested $7 million. The said sum is calculated using present value of free cash flow in the mid scenario of so and so. It is the tribunal view that if the respondents provide the claimant with control of the company, together with all assets provided for or contemplated by the SPA by 30th of September, the claimant should not be entitled to further and full damages calculated by Len. Now, then paragraph 380. However, in the event the respondent at any time prior to 30 September offered to give the claimant actual control with all or some of the assets provided without prejudice to the order, that the claimant may forthwith elect to receive the actual control, recover from the claimant additional damages, and paragraph 3. Now 382 is a pure guesswork. Guesswork by Professor Len, followed by a guesswork by the tribunal determines in the round that the additional damages for permanent loss of actual control to be awarded to 80 million. Taking into
Ponderables and accurately cannot be accurately calculated is in a sense a contradiction in terms, because it's imponderable, then it no question of inaccurate or accurate.
You have to overcome
the prefix IM takes away the ponderability of the apparently. Yes, you're right.
So this is a pure guess. And Lordship, just a few very useful from the recordings of the arbitrator. McKinsey's report, one thing, just to show, satisfy my Lord's conscience, McKinsey's report, those imponderables are stated.
That has been recorded many places.
13 million.
McKinsey report itself says that.
Which was never proved. Nobody came to prove the McKinsey report. No one came from McKinsey to prove.
Right. Yes. Nothing was ever argued before me that it was proved or something.
Nobody came to prove the McKinsey's report. McKinsey was their consultant whom they engaged. Somebody should have come. An expert's report does not become evidence unless he comes and proves it. And কি ওটা কি দেখাচ্ছি? ওটা কি তোমার দেয়া নেই? It's not part of the
What are you trying to show?
the McKinsey report.
That was produced sometime.
Was it produced?
Lost in the jungle. Never. আচ্ছা।
আমি কোথেকে দেখবো? আমার থেকে।
No.
Page 70 and 78.
McKinsey was entrusted with the job by the claimant.
By the claimant excludes claimant's holding company. Claimant's holding company, তুমি প্রথমে দেখিয়ে দাও প্রথমটা। The first page of the report.
Executive summary at internal page 4.
Internal page 4. That this is the holding company. here কোথায় পাচ্ছ কি তুমি? There's some evidence to show there's a holding company's engagement. No. There is some. This is the holding company. Well, there is there's other way. It is mentioned somewhere. That they were engaged by the holding
Yes.
company.
The usual disclaimer is also there.
Always, all reports have the usual disclaimer.
Has to be there.
Now, pages 70 and 78. What they probably doing? They were engaged by Health Inc.
70 and 70?
8. This is the projections that
Yes.
it can't be more vague than this.
Can achieve. 70 to 70.
70 and 78. This is the monetary part required,
Acha. Right.
which neither they have not shown the ability. Yes, Lordship was asking who had engaged them. That is in the award itself, it's mentioned. That is paragraph 174, page 70 of the award record, that the holding company had engaged. Before the contract, long before the holding company entered into contract.
Paragraph?
174.
Right.
At internal page 70. Now, kindly see page 70. Local would need to make investments and develop a range of capabilities to effectively execute these initiatives. Should the levers, initiative, first column, second column is one-time investment, I can understand. Third column is recurring investment, page 70. Now, one-time investment is given at the bottom, 3.5 to 4.5 million. Page 70 at the bottom, total second one-time investment is 3.5 to 4.5.
Yes.
And the recurring is 1.2 to 1.8.
So this was never assured. I mean, nothing was proved
And
to show that they had this.
Is it 1.2 million per month, per year? Read this also with page
Right.
76, page 78. Now, in upside 2, local can achieve $7 to $25 million in cumulative free cash flow by the end of 24, but will require $13 to $23 million in cash to fund it. And this applies to the entire local group. Oh, sorry, this applies to local. Only local.
Only.
কিছু বলার তো নেই কিছু বলার নেই nothing more. Why next occasion? Then why not keep it at 1 p.m. Once the lordship comes back at 1 p.m. just to show from the
Why 1 p.m. Mr. Mitra?
when lordship comes back.
It will appear in its usual course.
I'll take 10 minutes to 15 minutes maximum.
Heard in part for further hearing on August 8, 2025.
My lord will not be available next week.
For further hearing, comma,
नहीं, दो
on
सप्ताह
August 8, 2025.
8th August.
2 सप्ताह नहीं Judge Sahib.
8 not be there. Yes. Yes. এটা ঢুকে যাবে কোথায় কারেন্টটা রাখছো উপরে রাখছো কারেন্টটা ও কারেন্টটা কি উপরে রাখছো এভাবে
I'm as usual before your lordship.
This is as far as Justice Bharadwaj and I are concerned, back again. Justice Sarkar is the one you have to address.
I have to address Justice Short.
No, not that we may change our minds also, either of us.
What I was just wondering is if the administration can make a compilation of all the acts that they actually submitted while submitting before your lordship,
We will.
not before Justice Bharadwaj.
We were wondering whether we should request both of you to come prepared with your written notes of argument, because this is already heard by us. You will be advancing
Sarkar
arguments full-fledged. We will be hearing, and Justice Sarkar will obviously be hearing. So if you come prepared with whatever documents are necessary, both the judgments, whatever compilations the administration wants to. On the last occasion also they helped us like that.
Yes, that's exactly what I was trying to submit is if they can give it to us as well, because
Yes,
those
definitely.
documents are with them.
Fair enough.
It's not with
The
notification, the Government of India Act and
Right.
the ones related to that. If they can just give it to us a week before your lordships, whenever your lordship sits next, so I can also
See,
prepare
we have
myself.
consecutively in this order, I, Justice Bharadwaj, Justice Sarkar will be going to different circuits. So it cannot be before 15th September.
Very good. We have
We'll
enough
keep it on
time.
15th September.
We have enough time.
সব করে নি হ্যাঁ সেটা একটা তাহলে
Acts, my lord, we shall provide them today itself. We shall make a notes of argument.
yes yes
Just
you
all
provide
those
within a
acts
week
which
both of you
chronologically, my lord.
very well.
Because Justice I'm sorry. My lord didn't have my lord, the convenience of seeing those acts.
Yes.
That's why, my lord, that judgment had come. So if your lordship once looks into that, maybe your lordship would also, my lord, because when yes, that is
Because at that time, my lord, is arising out of a private matter. At that point of time, administration was not involved. But is there no question that they would have those acts and those things?
No, Mr. Chatterjee, Ms. Sharkar, Justice Sharkar has a sorry, Justice Sharkar has a point that
my lord.
that that sorry that the other party in your litigation whether they should be heard or not.
The other litigation.
No, not us. The
they-
private.
They are the
matter.
administration.
Before Justice.
Yeah,
Was for the,
they have to be heard also.
they should also be
The
heard.
litigants who say that
Polymers matter, that didn't happen. In the Deepak Polymers matter, which was sent to the larger bench, I was never heard.
No, but then we
Good.
think they should be heard. Their point we have to
Then
take.
let them serve.
because the persons who the party which argued before Justice Bharadwaj in support of
Mr.
High Court's
Mr. Shataruban,
Shatadru himself was there.
Yes.
he argued the matter. So I'll
He
inform you.
argued the matter. Shatadru
Andaman.
Shatarup.
Shatarup.
Shatarup was there.
Shatarup.
Shatarup bench. They should be there.
So I will inform Mr. Banerjee
Given
that he
notice.
can come and
Also
assist.
comment to what you have.
Definitely,
That
I-
activity also has to be heard.
My lord.
counter argument
To
on
the
both
admin-
counts. Administration is making a
I,
counter
in a
argument.
way, agreed with the administration. In a way. Because if your lordship remembers, my lord, when I was submitting in courtroom number 16, I did not oppose it after what came from, my lord, the administration on the Government of India Act. That's why
No, you opposed it.
I opposed
Did
it
oppose it.
because I
There's a
proposed it.
contested hearing.
Won the
They
case,
should remember.
that might
Yes,
be-
but then all the more Mr. Banerjee should be.
I will. Yes, exactly why. Exactly why. Because
shall
I
inform
felt
the
they had
record
reason.
At Portville. I shall inform.
Record
And I will
Which
inform
matter?
Mr.
What
Banerjee
is
here.
that matter number? Just give the number. We'll see. So that we can.
Justice Pattanayak was there.
Because Pattanayak বিবাস দে।
Pattanayak.
Justice.
Pattanayak.
Justice. মুখ হড়কে গেছে। What was the number of the other I mean, so that we can refer to
It's
it?
there in my lord's order, my lord.
আমার অর্ডার গুলো না এগুলো ইয়ে যখন থাকবে না জাস্টিস আমার ডিভিশন বেঞ্চ আর জাস্টিস ভরদ্বাজের ডিভিশন
FAT number 3.
এই দুটো
3 of
And
2022.
Mr. Nadeem Akhtar Khan
Order-
required them not to respond.
অর্ডারটা পাস also
FAT number 3 of 2022.
নোটিশ দেওয়া হবে আর যা রিলেভেন্ট অ্যাক্টের নোটিফিকেশন গুলো অফিস
Chatterjee learned senior advocate and Mr. What is?
Divesh Dwivedi.
no? Mr. Divesh Dwivedi appear for the appellant.
No.
No, for respondent administration.
Appear before
Alada.
this court. Mr. Dwivedi represents the administration.
আন্দামান নিকোবর
Andaman Nicobar administration. This bench is of the view that the learned advocates who appeared in FAT 3 of 2022, Robin Bakchi versus Dr. M. Joy and others, should also be issued notice so that they may appear before the court and make necessary submissions. Mr. Dwivedi shall issue the such notice upon the learned advocates who are for the parties represented by Mr. Shatarup Banerjee and Mr. Gaurav Purkasta and Mr. K. Vijay Kumar for the respondents.
And also Mr. Nadeem Akhtar Khan, he was also for the petitioner in that matter.
All further notice be issued on all learned advocates who had appeared in matters where a similar question was involved. 2 matters only, so it's okay. Mr. Dwivedi shall supply a copy of the acts, circulars, notifications which are relevant for adjudication of this matter to the respective advocates. The learned advocates are requested to prepare the written notes
Arguments.
of arguments.
And also advance the oral arguments in the next.
The advanced copies of the written notes of arguments be circulated amongst the learned advocates for the respective stakeholders in the matter, parties in the matter. And the matter shall the matter is made returnable on September 15, 2025, when oral arguments will be heard.
When should you keep it?
Whenever your lordship.
My last step. 15 September is a Friday. Sombar. It keeps it on a Friday or something, my lord? The Thursday or a Friday? Monday
Friday
is
hole
motion day, my lord.
If it's a Friday, it's better. Huh? So like 19th.
It'll be very, very close to the pujas. It'll be very, very close to the long vacation. Friday, 3 মানে half an hour.
তারপরে যদি সবাই কনসিড করে যায়
At 3 p.m.
ছুটির পরে।
না না 17 concede করবে
ছিল না ওর কাছে
The problem is the clients might lose interest by this
Mr.
time.
Banerjee will not going to concede.
that means you will not get your fees আর তো কিছু হবে না you'll have to argue as a lawyer
আমি তো রয়েছি, can have a complaint. I am here. The other.
Make all of you Amaikai.
I am here.
bye
My lord, I'm appearing. My lord, my apologies, my lord, for
Yes,
joining
yes,
in
yes.
late. My lord,
yes
I'm very
yes
sorry.
You can see blue sky. my lord.
No, no, my lord, I'm in court premises, Supreme Court premises. I'm not joining from park, my lord. I can turn on. I'm not. I would never do that, my lord. I would never do that, my lord. Sorry.
তাছাড়া ক্যামেরাটা ঘুরিয়ে দেখাচ্ছে no no acknowledged
give notice to all parties and then let's just
My lord.
thank you
great
Yes.
Call mentioning it. In view of the above findings, the impugned order dated February 15, 2025, taking cognizance of the offences made out in the complaints against the petitioners under the PMLA, being patently violative of the first proviso to section 223(1) BNSS, since no precognizance opportunity of hearing was given to the petitioners, is vitiated in law and a nullity in the eye of law. Accordingly, the said order dated such and such in connection with such and such is hereby set aside. Consequentially, the subsequent proceedings taken in pursuance of the said orders are also quashed in view of the genesis of such proceedings itself being a nullity in the eye of law. Thus, here are the four numbers are accordingly allowed in terms of the above observations. Urgent certificate copies.
Deeply obliged.
Thank you. Now, এটা পাঠিয়ে দিও আপলোড করে দেবো
My lord, it is set aside and remanded for fresh cognizance after giving them an opportunity for hearing.
No question of remand. No question of remand. You can take fresh cognizance again. There's
Very
a
well.
bar in that. So we have not put anything on that.
Very well. Very well.
This particular order has been set aside and whatever has been done pursuant thereto.
Very
so
well.
keep it open for you to whatever.
Very well. It will start from that. Very well.
Start from there.
Obliged.
Thank
Yes. 5 to 7.
Contempt none.
5 to 7, my lord, I have been requested to appear for CBI. Now, my lord,
What have you done? What is the contempt?
My lord, the challenges, my lord, to the FIR which was registered
Right.
by the CBI. Now, my lord, the challenges on 3 or 4 counts, and my lord, I'll make it good, my lord, I'll just narrate in my own words.
These are the CBI matters.
These are CBI matters.
Right.
This
Yeah.
is entirely different, my lord. Now, my lord, the CBI case is relating to, my lord, purported non-payment of, my lord, the credit facilities that were availed. There was a consortium of banks, and, my lord, the lead bank has filed a complaint on the basis of which, my lord, this FIR is registered.
That was under the master direction. Fraud master direction.
Well, kind of, yes, my lord. So, my lord, that fraud classification had already been quashed by your lordships much prior to registration of the FIR, with a, my lord, further caveat that all consequential proceedings would also go. Now, my lord, whether in the
Mr.
wake of, my lord, the
Chakravarti,
latest Supreme Court,
Mr. Chakravarti, take your seat. Yes.
my lord, I'll just narrate, my lord, in my own words.
Yes, Mr. Chaudhary.
I'm sorry
Absolutely.
to interrupt, my lord.
My
Has
lord.
my lord
not only the thing that my lord, the reply has been served today at 11 o'clock in these 3 petitions.
No,
yesterday. And I have been requested, no, this voluminous petitions kindly accommodate us. And I understand that
Allow me to preface it, my lord.
You will also be leaving for Andaman for Monday.
Not Andaman, Jalpaiguri bench. I have a circuit in Jalpaiguri circuit for 2
Interim order
weeks.
Extended, but will not kindly give us an opportunity.
There was an interim order in your favor.
There's an interim order. That, my lord, is up to 31st.
Then we'll extend that
Interim order.
for a particular period. We'll extend it. Mr. Chakravarti will explain. We are coming back. I'm coming back on 4th. So we'll keep it on 8th. We'll extend the interim order till 31st. Some difficulty.
So
Then the next
date is
Friday
22nd.
available is 22nd.
Yes, after 15th August.
So then we'll extend the interim order for 30th September or until further, whichever is earlier.
Please, my lord. And then, my lord, any specific day, my lord?
Yes, definitely. 22nd of. So 22nd, please take up both of your diaries.
August.
22nd of August.
22nd something. Any other
Always.
of your choice.
Lord, my brother has.
I have some personal plan. Right. If 29th is okay with you.
No,
Whatever suits both of you, both sides.
Then next date is 29th.
Sir,
The
he's coming.
29th, whether they have, I don't know.
Fridays.
29th.
So many diaries on that side, Mr. Chakravarti.
My lord, I think take it little early, my lord. The lordships are coming back on 4th.
Yes.
Let it be, my lord, before 15th.
8th, your learned brother has a problem.
8th, 10th, 11th, 12th, whatever.
The learned brother behind you has a problem on 22nd.
Only on Friday.
8th, Friday. This bench is taken because we
Alright.
have a division bench otherwise.
Please, your lordships.
That's why.
So 8th Friday, my lord, then
8th blocked,
22nd.
22nd blocked, 15th Independence Day,
All right.
29th is the next date.
All
Friday.
right, my lord, sir.
See if it suits all of you.
29.
Very well.
All right.
I'm sorry.
Learned ASGI, having instruction to appear on behalf of the CBI, seeks an adjournment in the matter on the ground that a copy of the reply has been served on the CBI earlier today.
No, my lord, yesterday, in fact.
Yesterday, probably. Only
One copy and today attendance was not
last evening. Full stop, next para. Accordingly, let the matter stand adjourned till August 29, 2025, when it will next be listed under the same heading. The interim order granted earlier stands extended till September 30, 2025, or until further order, whichever is earlier.
My lord,
Yes,
if
Mr.
my brother wants to file any sir rejoinder, that may be filed, my lord, well in advance, at least 2 weeks in advance now.
It will never end, Mr.
All right, leave it.
If you want to do anything, Mr. Chakravarti, unofficially we are telling you, I mean, we are official. But generally we deprecate, you know that after reply, we don't call for any further affidavits. No,
unless Lord,
new, something new.
Yes, something.
If you see something new, if you want to use an affidavit, please give advance notice, give advance copy, well in advance, at least 3 weeks before. You are getting much time, and use that.
Deeply
We are
obliged.
filing this reply.
That is a reply. Opposition you have filed.
Yes, yes. This,
Very well.
these are only, my lord, documents, basically documents.
Very well. The affidavits in reply filed today be kept on record. Thank you.
Deeply obliged, my lord.
Thank you so much.
Deeply
Three
obliged.
volumes, my lord, in each.
Only-
I'm sorry to interfere.
Well, does it suit this matter? Yes, sorry, Mr. Chakravarti. Yes.
My lord, since I was entered belatedly, I could not hear the judgment.
The judgment you'll hear it from your
Hussain
friends.
was here, Zohaib Hussain was here from Delhi. He was very much.
Yes.
Since my lord, I
Someone was there, Mr. Chakravarti, on your behalf.
very well,
Yes,
my lord, I will hear from them.
No, 29th at 2 p.m. as usual.
29th. Appellate side matters are taken up at 2.
For the petitioner,
Automatically
Lordship. For the petitioner led by Mr. Raghunath Chakraborty. On the last occasion, Lordship, the contempt petition
This
was,
is item 8.
yes, Lordship, was initiated against the order dated 21st August 2023 regarding the disbursement of the pensionary benefit. That was also challenged by the challenge on the division bench. MAT 488, Lordship.
That has been
is
dismissed.
Dismissed.
Now you have to comply, Mr. Prasad. What was the nature of the order?
My lord, if my lord will come to page 25 of the contempt petition.
Just you are
Hello?
taking us to the page 25 of
My
the
lord, the ARC is coming for the retiral benefit. My lord has directed to
Be
do
paid.
the needful and disburse the same.
So then do it.
Yes, my lord, only one thing, kindly consider, my lord, one of the alleged contender, my lord has retired from the service.
So has to be
My lord,
changed.
he has to be substituted. The
Please
director of,
furnish the name of the
Yes.
present incumbent.
Liberty to
We'll do that. Right. Has it been supplied to you, the particulars?
no,
my
Lordship.
lord,
Mr. Prasad, don't
I-
take a risk. Supply in writing
Yes.
to the itself.
I have given, my lord, she will do the needful in the
Very
meantime. Only one prayer I am making, my lord. We need a approval from the finance department. Kindly consider, my lord, my instruction as of now, what we have done.
May I get it, Lordship? One another copy.
আমি দিয়ে দিচ্ছি একটু স্যার।
So let us see what it is first. Do whatever you have to do. You comply. এটা ফেরত দিয়ে দিন।
Yes, my lord. We
No,
need
further indulgence. Sorry.
no,
No.
my lord, we want
When
some,
was the appeal dismissed? The appeal was dismissed on 12th of June. Today we are on 18th of July. More
My
than
lord-
1 month has elapsed.
my lord,
So when the appeal was dismissed, if you did not take a decision to prefer an SLP, Mr. Prasad, you knew on that date.
my lord,
So no.
some more time, my lord. I am seeking some time to be given because
Acha, who is the container who has
my lord,
limited of
that is the director of health services.
which one?
The
One,
alleged
number one.
contender number 1.
Dr. Siddhartha Niyogi
Yes,
has been. He has also demitted of it.
yes, both.
So people are demitting office after each stage of the matter.
My lord, during the pendency, my lord.
Very well. It is submitted by learned counsel for the alleged containers that the substituted alleged container number 1 has since demitted office. Full stop. The particulars of the current incumbent in the said post have been given to you.
Yes, yes.
Yes, Lordship.
I have
Shall be given during the course of the day by the learned advocate for the alleged containers to his counterpart appearing for the petitioners during the course of the day, full stop. Leave is granted to the learned advocate on record for the petitioners to carry out the necessary amendments to the cause title of the contempt application by incorporating the name of the current incumbent in the post of alleged content number 1 by July 21, 2025. By Monday, do it. Try to do it today.
Yes, Lord.
Which of next para? It is submitted by the counsel for the petitioners that by an order dated June 12, 2025, comma, an appeal which had been preferred against the parent order, comma, which is under contempt, comma, dated August 21, 2023, comma, has been dismissed, comma, thereby affirming the order under contempt. Full stop. As such, comma, it transpires that there cannot be any further impediment in compliance with the order under contempt. Full stop. Learned counsel appearing for the alleged contenders seeks some time for such compliance, since necessary approvals have to be obtained in the meantime. How soon? Fortnight?
Fortnight, 1 month time is required.
No, you knew on 12th of June.
Because
3 weeks.
My lord, I cannot bargain on this issue as your lordship.
What was your instruction? 4
My lord,
months or something?
My lord, they short more than 2 months, but I am leaving to your lordship.
Lordship, personal appearance was also dispensed regarding the
Personal appearance was dispensed with.
dispensed because the appeal was still pending.
No, that is democracy's sword. We can revive that again.
Yes, my lord.
কি বললাম চেষ্টা কথা করলাম জাস্ট বললেই হবে
Can you give a short date?
6 sometime না করে 6 at least 2 months time to comply with the for such compliance for such compliance. Full stop. Next para. However, comma, it is seen from the photocopy of the server copy of the order dated June 12, 2025 that the appeal preferred against the parent order of this court was dismissed in the presence of the appellant, comma, that is the alleged contenders, comma, on that date. Full stop. Hence, comma, more than a month has already elapsed after the date of the dismissal of the appeal, and, comma, as such, comma, there could not have been any justification for the alleged contenders to wait for so long to comply with the order. Full stop. However, comma, given the fact that certain approvals might be required internally on the part of the alleged contenders to comply with the order, comma, a further month is being given to the alleged contenders to comply with the order of this court. Full stop. Let the matter be listed next on August 22, 2025. Comma. When an affidavit of compliance shall be filed by the alleged contenders with a prior copy of the same being served on the learned advocate on record for the petitioners. It till dispensed with personal appearance?
Yes. My lord, I am led by Mrs. Sonal Sinha, my lord.
Mr.
Sonal Sinha in this.
He is there in court?
Yes.
Yes. Give it.
I'm Yes, my lord. In this matter, I am appearing for the petitioner.
Yes. What is the matter? What is the content? Appearing for the first time?
No, your lordship kindly see the order dated 13th June 2025. I am filing the affidavit of service. Your lordship, in pursuant to your lordship's order, one copy of the Ministry of Home's Deputy Director, without announcing anything, send back. I have written in my affidavit in observation. All the.
Don't you have a track report? Track reports are available on the website.
There is kindly see the affidavit of service page
left.
Page nothing.
This, yes, left. Who has left?
Ministry of Home's Deputy Secretary. And the Chief Secretary Manoj Pant and the Home Secretary Nandini Chakraborty have received.
Have received?
Yes, my lord. I have
number one has returned as left.
Number 3, I think number 6.
The rest have been served.
Yes, rest has been served. I have filed the affidavit of service.
What was the nature of the contempt?
Contempt is the pension regarding freedom fighter pension. Your Lordship passed the order on dated 6th February 2020. And Your Lordship come to the order page 65, running page 65, awarding portion of the order. Then thereafter I have filed the 3 application. Number of letter has been exchanged between the central government and state government. Nothing has been seen. Now the age 101, he is bedridden, my lord. Fortunately,
This is the freedom fighter himself. This is the freedom fighter himself, not
yes,
theirs.
my father was the freedom fighter. He was the associate of my father. Therefore, I have come to every time and to give the honorary service. In addition to that, I have argued in that.
Your father?
Yes, my father was the freedom
fighter.
And
No,
he was the
Mr. Satish Chandra Das is now one.
Mr. Satish Chandra, the associates of my father.
He was 101 years. He's
Yes,
100
now 101 year. He is bedridden. Now he is father.
They have not even
Son-in-law
taken.
has come to me.
Sorry,
to
they
give
have
the
not even
instruction.
taken a decision on this.
Yes,
That-
my lord.
No decision.
No
Only-
decision. Only few letters has been exchanged. A number of times and called by the governor, honorable governor, to give the state guest honor of the state guest on the date of 15th August and the 26th
What
January.
does the postal track report of about this says about number 6?
And repeated time.
যেটা দিন তো নাকি? What does the postal track report say? We get the envelope.
All
This is this the correct address?
yes, my lord. The correct address in the Navanno. Or the I have.
No, this is number,
all the
number 6 is North Block, New Delhi. What are you saying? No, no.
number 6 did not received.
We are asking only that about 6. Rest have received.
Yes, my lord.
So why one has received?
All are received.
You are saying 6 has come back as left. What is the address? This is the right address. North Block, New Delhi. That is what. This is the complete address.
Yes, North Block, New Delhi, deputy.
Checked up whether
Secretary
this
of the
Shiv.
Ministry of
Have you
Police.
checked up whether this Shiv Kumar is still the deputy secretary? Left. That is why you are worried. The office could not have left. We don't know whether the office has been shifted.
Office is there. Office is there.
This Shiv Kumar must be must
Office
have.
is there.
But regarding the rest, will issue a rule.
And with regard to the others, my lord, the state government.
Will issue rule.
Yeah, all right.
Learned counsel appearing for the petitioner submits that the petitioner, freedom fighter, is now 101 years old and is bedridden. Full stop. Despite the order under contempt having been passed in the presence of the respondents, the same has not yet been complied with. Full stop. Next para. From the affidavit of service filed today, it transpires that all the alleged containers, barring alleged container number 6, have been duly served with notice as per our previous, this court's previous direction. For sub next para, by the order dated February 6, 2020, WP 4725 within bracket W of 2011 was disposed of by directing the respondent number 6 to transmit the NARC in respect of the present read petitioner to the respondent number 3 within 3 weeks from date. First up, upon receipt of such NARC, the respondent number 3 was to process such application and take a decision on the same as early as possible, preferably within 1 month from the date of such receipt, and to communicate such decision to the petitioner in the event the petitioner apostrophe's application was refused. Full stop. In the event the application was granted, the authority was held to be responsible. The authority responsible for disbursing such amount was to forthwith remit the amount to the petitioner. Achha, apart from 3 and 6 in the said writ petition, why have you implemented the others? What is their role in the contempt?
I implemented others on the order dated 13th June 2026. You Lordship see, You Lordship directed. If remitted or transfer, then in that event.
They are the current functionaries.
Yes, my lord.
Very well. However, despite service, the alleged containers choose to abstain at the time of hearing of the present contempt application, full stop, since it is alleged that the order dated February 6, 2020 has deliberately been flouted and no communication has yet been made to the petitioner as to any decision being taken refusing the petitioner's application for freedom fighters pension, comma, nor has any amount been disbursed in favor of the petitioner, comma. This court finds a clear case of contempt having been made out. Full stop. Next para. In view of the alleged container numbers 1 to 5 having chosen to remain unrepresented despite service, comma, there is no option for left before the court but to issue rules of contempt. Full stop. Accordingly, rules of contempt be issued in respect of the alleged container numbers 1 to 5 individually, comma, calling upon them to show cause as to why the said alleged containers shall not be penalized in terms of the prayer made in the contempt application. Full stop. The rule is made returnable on August 22, 2025 at 2 p.m. Full stop. Next para. Insofar as the alleged container number 6 is concerned, comma, the petitioner shall ascertain as to whether there has been any whether the said alleged container is still in office. Full stop. If so, comma, a fresh service shall be effected on the alleged container number 6. Full stop. In the event someone else is now manning, MANNING, the said office of the alleged container number 6, comma, leave is granted to the learned advocate for the petitioner to amend the cause title of the contempt application and incorporate the name of the current incumbent and serve a copy of the contempt application on the said newly implemented alleged container number 6 in the meantime and file an affidavit of service to that effect on the returnable date. Ascertain new person, amend the cause title, serve, if not same person. And regarding the others, 2 p.m. 22nd August.
I'm grateful to Lord.
Thank you so much.
Highly grateful. I am for the CSC authority.
Order has already
Complied with.
Complied with.
Why are you so sad? You're the petitioner.
No, my lord, I am for the Alice contempt.
Oh, that's why you're sad. Who is for the none appears for
But
Achha.
on the last occasion, nobody appeared.
Nobody.
Your Lordship was pleased to direct.
What was the
me-
nature of the direction?
But there was a direct.
You're appearing with him.
No, I am for CSC authority. I am for CSC.
Both of you are alleged contemners.
Yes, Lordship. But the thing is, Lordship, the specific order was for restoration of supply. There is no disconnection. And we have made restoration of that supply. Now, at this present, we have nothing to do with this, Lordship.
No, what was the direction?
The order passed.
Yes, my order.
Order passed by your Lordship on 2nd of March 2022. If your Lordship kindly see the order itself,
yes,
where there is no inaction on the part of CSC authority.
No.
There was a private dispute between the petitioner and the private respondent. And on that basis, the common meter board exists in
No,
the...
you're directed to restore the
Restored. That has already been done, Lordship. That has already been done.
So what has not been done? What is their allegation in the contempt?
I don't know whether there is any specific... Because the copy has not yet been served to us. On the last occasion, your Lordship was pleased to direct me to intimate the petitioner's advocate. Now, I have intimated him. He said that I am not appearing here. This is the letter, your Lordship.
And what have you said? How complied? What was your role? Police assistance?
No. BLRO demarcation done by the BLRO.
কোন ম্যাটারটা না না এটা
Which
আপনার
matter?
না এটা আপনার না 10 নম্বরটা অন্য ম্যাটার ও তাই আপনি বলছেন কি বুঝছেন নীলাম্বর মুখার্জি চলছে
ফেরত দিন এটা ফেরত দিন ওটা অন্য ম্যাটারে ইয়েস
এই আপনারটা এটা দেখুন It seems they have lost interest in
None
this.
appears for the petitioners at the time of call.
In
Full stop.
pursuance to your lordship direction, I have already intimated.
It is found from the records that the petitioners have remained consistently unrepresented on the last few occasions, being May 23, 2025, June 13, 2025, and July 11, 2025, on which occasions the contempt application was called on for hearing. Full stop. Next para. As per previous direction of this court, the learned advocate appearing for the alleged contemner furnishes a receipt of a notice sought to be served on the advocate of the petitioner. Full stop. The endorsement of the said learned advocate thereon shows that the said learned advocate has no instruction now to appear in the matter. Full stop. Next para. In any event, learned counsel appearing for the alleged contender submits that the order of this court has been complied with by restoring the electricity connection of the petitioners. Full stop. Hence, it is evident that the petitioners have lost interest in the contempt application. Full stop. The receipt filed today in court be kept on record. Full stop. In view of the above observations, CPAN 386 of 2022 is disposed of as infractuous. No address to costs.
I am deeply aware.
It recorded থাকবে.
Item number 11.
Let it be called on.
11 minutes. I am for the petitioner. This is my affidavit of service. I have already served them.
They are saying it has been, yes, hand it over. They are saying it is complied with.
Partly complied with.
What was the direction?
Direction was to go for an inquiry, give reasonable opportunity of
This
hearing.
is the unauthorized encroachment or what?
No. Whether the impugned WB ACDCL pole was on my land or not. That was the question. So direction upon the BLRO to ascertain it. So how they would ascertain, they would serve me a copy, go to the inquiry, reasonable opportunity of hearing, and after that delivery of.
No, district magistrate was directed.
No, respondent number 4 was the BLRO. BLRO was directed.
Which
After that,
the parent order is dated 18th of April.
yes, internal page number 3, Lord, of the.
Achha, yes.
Paragraph number 3.
First, the BLRO hold a fresh inquiry. Achha, that has not been done, you are saying.
Inquiry was done, but order was not handed over to us.
Yes, you had to send copies of the report to the interested parties. What about that?
Page 6.
You give a copy to him also. Should have extra copies.
Yes,
Then if subsequently they have maybe received, I don't have the instruction.
Sajal Bishas received.
Yes, Sajal Bishas received. I don't have the instruction.
Take instruction. Affidavit of service filed today be kept on record. Full stop. Learned counsel appearing for the alleged contemner hands over a bunch of documents, including a communication of the decision taken by the BL and LRO in the form of a report to the petitioners. Full stop. The said copy indicates prima facie that such copy was served on the petitioners, contrary to the allegation in the contempt application that the BLLRO has not served any copy of the report on the petitioners. Full stop. On the prayer of learned counsel for the petitioners, the matter is adjourned till August 8, 2025 for the petitioners advocate to take instructions in that regard. Full stop. Let the matter be posted for hearing next under the same heading on August 8, 2025. The bunch of documents handed over on behalf of the alleged contemners today be kept on record.
Great.
So that is the only contempt.
Yes.
I am for the petition.
Yes, Vishal.
For the contemptor, Lordship, on the last occasion, there was a direction upon the alleged contemptor to file affidavit in opposition, Lordship.
It is my mistake.
Just
but
today, I have
some
received the copy,
part
Lordship.
Slipped out of my mind to sir. I served him
I
today
need
morning.
some time to
But
file the
we have-
reply in this matter, Lordship.
What is your stand in this?
No, we have, my lord, given letters and all. There was no direction upon the police, my lord, to.
Acha, do you require a direction, Mr. Mukherjee, on a more basic premise? CSC personnel can always, they do approach the police, corporation, CSC.
Kindly see the annexures which I have put in, Malak, in my opposition, Malak. Page 9 onwards.
Yes.
It is in 16.7, paragraph 2.
Objection raised, yes.
We have written, Malak, to
Lordship,
police officials.
although I'm
Malak,
praying for time to file the
time
reply.
paragraph page 12. This is the to the officer in
Lordship,
charge, Malak.
what the CSC officials are doing in this matter, Lordship, the order was to give the loop metered connection in 68 Thakurpukur Road, Lordship, in the writ petition.
He is opening a new case
No,
which
no,
was
no, no.
not
I am
laid
just
out in the writ petition again in
yes,
the
yes.
in the contempt that was observed by your lordship on the last occasion.
Yes. They are going
Very
to
well.
give the connection in
The affidavit in
76
opposition filed today be kept on record. For so learned counsel for the petitioner seeks some time to use a reply since a copy of the opposition has been served here and now. First up, accordingly, let the time for filing reply be extended till August 8, 2025, when the matter shall next be listed under the same heading.
Grateful.
I am obliged. Ma'am.
Thank you.
I am instructed
Yes,
to
Mr.
appear on behalf of the contemner, alleged contemner.
What is the nature of the contempt, Mr. Bandyopadhyay?
Consider the representation, madam. Representation dated 14 November.
Consider the representation. They have not given any hearing. They have not given any hearing.
No, madam.
Achha, yes, Mr. Rai, what is the instruction? Evidence service.
Hearing was given, he was present. That
File your opposition. You have got a copy of the petition. You have got a copy of yes.
I have got, but without any annexure, my lord, only.
Oh. Mr. Bandyopadhyay, please give copies of the annexures.
Yes, my lord.
In the course of the day, please.
Yeah, my lord, I'm communicating.
Annexure is only the order.
They have given notice.
No. There are some other things also.
Sufficient.
Communication, yes. Mr. Bandyopadhyay, please ensure that the annexures are given today itself.
complete sector thing.
Take up, just cross check whether it has been given.
Last time, my lord, page 20, they have issued notice, my lord.
Complete contempt application to complete.
Learned counsel appearing for the alleged contemptor submits that the annexures to the contempt application have not been served on him, on the alleged contemptor. First up, learned counsel for the petitioners is requested to serve copies of the annexures to the contempt application on his counterpart appearing for the alleged contemptor during the course of the day. Mr. Bandyopadhyay, please do it today itself.
Yes, my lord. Yes.
Mr. Rai, you can help him by taking up photocopies. Yes. Because the next para, the affidavit of service filed today be kept on record on the prayer of the learned counsel for the alleged contemptor. The alleged contemptor is directed to file affidavit in opposition to the contempt application within August 1, 2025. Reply, if any, shall be filed by August 8, 2025. The matter shall next be listed on August 8, 2025 for hearing.
Here and now, my lord, I have.
He'll not deny. Mr. Rai generally does not deny. I have never seen him deny, but there may be a first for everything. Yes. Yes.
My lord.
For the first time.
Contempt has not been admitted. Why? Well, the order under contempt has already been complied with, and the district magistrate is threatening me. If you do not withdraw the contempt, in spite of being complying the order, I will take steps against you.
Acha?
Magistrate calling me up, and sir, I will comply the order. The contempt has not been admitted.
Your
Why are you
client
so
calling you or your client?
calling me that I will be taking steps against your client. Why are you not withdrawing the contempt? And that is the reason why I think why my learned friend is engaged in the matter. My
Judicial is concerned, my lord, we have already shifted. We have, my lord.
My order has been complied with. Order has been complied with. I admit to that, my lord. The content has not been admitted. I don't know, my lord, why my counterpart is appearing in this matter.
For saying that.
For saying that, my lord, that has not been admitted. My lord, the contempt.
If you want to, but that will be a criminal contempt. Leave
My lord,
it.
I do not want.
You lodge a diary.
No, my lord.
Against the district magistrate. Learned counsel for the parties submit that the order under contempt has since been complied with. Full stop. Accordingly, CPN 1123 of 2023 is disposed of as infractuous. No arrest to cost. Mr. Kule, please ascertain whether he is doing that, Mr.
But
I have followed
magistrate. I am not WBSCDCL.
but I do not
We have
want to
done
praise
the
that
work.
thing, my lord. I don't want to praise that thing, but
Actually,
this
my
is
lord, there
the
is a
problem.
If he does so, you can lodge a diary. If you're an advocate, you can file a formal complaint with the police. Wherever you receive the call, even in your home, that police station, you can lodge a formal complaint.
I am not district magistrate. I am not appearing in the district magistrate.
Thank God you are not.
Otherwise, I will be in difficulties.
No. Not you, your client. Yes,
This matter also, my lord,
14.
after your lordship's order, another writ petition was filed, and they admitted the dues, and in fact, the 50%, another 80,000 they have already deposited.
What was the order under contempt? What had I directed by the order?
Well, that contempt was not served, but it is since my lord, the subsequent development,
What was the order? My order. What was my order?
That's my lord, your lordship.
You had to give opportunity of hearing, provisional order of assessment,
Yes.
and to pass a final order of. You have done that
Yes, that has been done, and subsequently they have filed another writ petition.
against the final order.
Yes, and they have admitted the dues, and the court passed an order
Acha.
directing the.
You should have brought a copy of that. It
That
would
order.
be easier for the court.
My lord.
Anyway, I will record your submission.
Copy, my lord, in the website it is there. But
No, I don't disbelieve you, but for the records. Anyway, I'll record your submission.
my lord, print a copy and.
Then, can you do it during the course of the day?
Yes, right now.
We'll ask you to do that. This is the second occasion after July 11, 2025 when none appears to move the contempt application. Who's up next para?
But for your lordship satisfaction, only see I.
No. You're saying that is the tenor of the order under contempt was that the alleged contemptor was directed to give a hearing to the petitioner and to pass a final order of assessment in terms of the provisions of the Electricity Act. Full of next para, learned counsel appearing for the alleged contemptor submits that in the meantime, such hearing has been given and a final order of assessment was passed against which a writ petition, against which an appeal was preferred.
Writ petition.
Against which a writ petition has been preferred by the
WPA number, my lord, 6030 of 2025.
By the writ petitioner bearing WPA number
6030
of
2025.
Of 2025. Full stop. It is further submitted that the petitioner has also deposited 50% of the admitted dues of the dues. Full stop. Next para. As such,
50% he has already paid for preparing appeal. Balance 50% and 80,000 he has paid.
That has been paid.
50% for preparing an appeal already paid.
Plus 50% here. The rest has been paid.
The rest 50%, 80,000 paid. An installment has been granted by the court. First installment 80,000 yes.
So it is further submitted to 50%. So next para. Thus, it is submitted that the order under contempt has been complied with. Full stop. In any event, we find that the petitioner is recurringly absent and as such has lost interest in the matter. Full stop. In view of the submissions of the alleged contemptor, CPA 1194 of 2023 is disposed of as infructuous. Full stop. The learned advocate appearing for the alleged contemptor is requested to shall file a copy of the final order of assessment.
Not final order of assessment, not with me. The court's order is with me.
In
court's order, it was mentioned, my lord.
Need not.
That final assessment order was.
Need not. You have said we have recorded this WPA number, that is sufficient.
And this order I have right now, my lord. The subsequent order, my lord, today I will.
No, need not file anything. No. If you can, Mr. Kohli, communicate this order to the petitioner's advocate or the petitioner, so that if they have any grievance, they can file a recall and we can take it.
Yes, of course. Because subsequent order, this court already stated that final order of assessment was done and against.
We have recorded that final order has been passed and they have filed a writ petition.
Yes.
If they have filed a writ petition, we have given the number that itself shows that that order has been passed. That is sufficient. Next. None appears for the parties at the time of call. We find from the records that on July 11, 2025, when the petition was last taken up for hearing, none had appeared for the parties as well. Accordingly, CPN 1410 of 2023 is dismissed for default without any order to cost. Next. This is the second occasion after July 11, 2025 when none appears to move the matter. Accordingly, CPN 1413 of 2023 is dismissed for default without any cost. Yes.
I'm for the petitioner, my lord, but this is a change brief which we have just received, my lord. I don't know whether I can even appear, my lord, because we have still not got the NOC.
Then
My
very
lord,
well we will not dismiss because in any event the previous advocate is not appearing. So we'll give you 2 weeks time because I'll be out in Jalpaiguri circuit bench. So we'll put it on 8th of August. 8th of August, yes.
my lord will come back.
What is your full name?
Shantanu Talukdar.
Shantanu?
Shantanu Talukdar.
Talukdar. You will file the wakalatnama.
I'll file the wakalatnama, my lord.
Mr. Shantanu Talukdar appears and submits at the time of call that he has been instructed to appear for the petitioners. However, no change has yet been obtained from the erstwhile advocate for the petitioners. In any event, the erstwhile advocate is also not present in court today. Accordingly, on the prayer of Mr. Talukdar, let the matter stand adjourned till August 8, 2025 to enable Mr. Talukdar to file no objection vakalatnama and appear in the matter. The matter shall next be listed accordingly on August 8, 2025 under the same heading.
Deeply obliged.
ওনার নামটা লেখার সময় না give your names ওই having instruction advocates having instruction to appear for the petitioner এইভাবে লিখ
There are perhaps two contemners.
You are for the alleged contempt, na?
Well, I don't know whether
You don't know.
I don't know because
Then why are you appearing?
because my seeing the cause title,
These persons have instructed you.
no.
Cause title, no.
The
The alleged
district
contempt.
district magistrate the first alleged contempt. The second one, I don't know from the cause.
No, first alleged contemptor has instructed you to appear. If
Whether
what is your occasion to appear? That is what.
I am for WBACDCL. I appeared.
Oh, achha, in this matter, the writ petition you had.
Petition. So I don't know whether any allegation has been put in this.
No, they are not appearing. This is the second.
The second contempt.
This is the second occasion after July 11, 2025 when none appears to move the matter. Accordingly, CPN 1615 of 2023 is dismissed for default.
My lord.
Yes, Mr. Adok.
I got connection, but my lord.
Connection, electricity connection was the contempt.
My lord, but my lord, part of this complied, my lord, because my lord, I have paid 24 lakhs. My lord, this is the underground line. And my lord, as per underground line, my lord, twofold wire was my lord installed. But this pipe was installed, my lord, one is not installed till now, my lord.
So no
Because, my lord,
complete.
one is hampered, my lord, one is running. My lord, this
No,
is
two connections, why?
I tell you, Lord.
Yes, explain, Mr.
But there is
Dr.
a
Sir.
technical issue, which my learned friend is saying this is not the scope of this order, subject to lordship kind approval.
Order was directing to
Order
give
was
connection.
yes, already connection has been given, and now some excessive payment has been given. My instruction is that will be refunded very soon, lordship. But that is not the criteria of but the connection has already been given, lordship.
That is the scope of the
Yes,
contempt.
that is the
What two connections? One connection you do?
no, my lord, I have paid 24 lakhs. As per their requirement.
The more you pay, the more number of pipes have to be put on the wire.
No. My lord, because my lord, underground line, my lord, one is my lord damaged, my lord, one is running, my lord.
Extra, that's
My lord.
connection has been given. How can
Yes,
you?
my lord, kindly, my lord.
Will record your thing.
This submission, my lord, refund, my lord.
No,
very
this is
short
not
Oh, I should
scope
do.
of the writ petition.
Learned counsel appearing for the alleged contemptor submits that in compliance of the order of this court, electricity connection has already been given to the petitioner. Whose learned counsel for the petitioner submits that although connection has been given, two alternative what is that pipes?
It is a two-way pipe, but the expert saying that it will suffice the situation when the pipe has been given. The connection has been, there is no
That the collection submits that the connection has not been given by two pipes.
But it is not the order.
Wait. Full stop. Next para. However, upon a perusal of the order under contempt, it transpires that the direction was only to give electricity supply which has already been done by the alleged contemner. Full stop. In the event the petitioner has any further grievance, comma, furnishing a fresh cause of action, comma, the petition, it will be open to the petitioner to challenge the same before an appropriate forum. Hence, CPN 1618 of 2023 is disposed of as infractions without an order to prosecute.
I am deeply obliged.
I'm on behalf of the petitioner and led by Senior Advocate Gopal Chandra Ghosh. He is out of station. Kindly pray for.
No, what is the nature of contempt that you have
Complied with. Was that
contempt of that? Without Mr. Gopal Ghosh, we won't take the risk of. What is this? Compliance will take on record. Give a copy. You have given a copy.
Yes.
An adjournment is sought on behalf of the petitioner, Full stop Learned Counsel, appearing for the alleged contemners, files an affidavit of compliance affirmed on June 11, 2025, which is kept on record. Full stop. On the prayer of the petitioner, the matter is adjourned and shall next be listed on August 8, 2025 for passing further orders.
When the matter was taken up last, Mr. Ghosh had said that it is going to be complied because his client had come to know.
Mr. Ghosh is not in town.
No.
Not in town.
Bankura.
Yes.
I appear for the alleged contemner.
Alleged contemners.
Yes, my lord, we preferred an appeal against my lord's order, which is
When after the contempt was filed, obviously.
No, my lord, this was prior, possibly. No, it was prior, my lord. I'm fairly certain.
Oh, for a change.
Prior, my lord, and
My lord,
my lord, one
let him finish, we'll come to.
only one submission. We had mentioned on 4th of July, my lord, the appeal, the application for stay was taken up. Affidavits are complete there. My learned friend did not appear for the respondent appellant. Thereafter, the honorable bench asked me to mention the matter. I mentioned the matter on 10th. It's due to appear in the daily list on any day. We kindly adjourn it for a period of 4 weeks. Or, I would only humbly
Very well.
beseech, my lord. If
Yes, what is your?
My learned advocate, Mr. Joy Chakravarti is engaged in other court, so praying for not today.
As you give your name, we'll record your name, we'll give them time till because the appeal is pending. An adjournment is sought on behalf of the petitioner, Full stop Learned Counsel, for the alleged contemner submits that an appeal has been preferred against the order which is under contempt. Full stop. It is further submitted that in connection with an interlocutory application filed in the appeal, comma, affidavits have been exchanged and the matter is due to be listed any day. Full stop. Accordingly, 4 weeks adjournment is sought on behalf of the alleged contemner. Full stop. Next para. For the sake of judicial propriety, comma, since an appeal against the order under contempt is now pending, comma, let the matter stand adjourned till August 22, 2025, when it will be listed next under the same heading.
obliged. My lord, will kindly not take me amiss.
For preferring the appeal, we are very perturbed that our orders are being challenged in appeal. How dare you?
Obliged.
Yes. Petitioner.
Yes, Lord.
Yes. Have you practiced saying yes 100 times before the mirror?
Yes, Your Lordship.
Yes.
I'm appearing on behalf of the conducting
It was yeah on the last occasion. That's right. No, Mr. Gupta must have changed that. Yes. Sorry, yes.
My lord, I am appearing on the request of the conducting advocate of the alleged
What happened to him?
he is suffering from cervical pain, my lord. He is not coming.
What was the last order, Mr. Gupta?
They haven't served us the supplementary affidavit regarding
They were given liberty to file a supplementary. What about that? Have that copy.
My lord, as I was instructed, the partial compliance has been made. There are two contemners.
No. You are directed to file. You sought.
communications which they made with the civil authority
You had to file a supplementary affidavit
regarding the communication.
to the affidavit of compliance. That was your prayer. What is that?
My lord, that is why I am seeking time on behalf of the conducting advocate, my lord.
We'll give you 1 more week time to do that. We'll grant that time. We'll keep it on 8th of August.
My lord, partial compliance has been made. One.
We'll record that. We'll record that, but we cannot, unless you use that supplementary affidavit, you cannot. Anyway, an adjournment is sought on behalf of the personal ailment of the learned counsel for the alleged contemners. Full stop. Next para. Learned counsel appearing for the petitioner submits that no copy of any supplementary affidavit has yet been filed. Full stop. we find from the order dated July 11, 2025 that on the prayer of the alleged contemners, liberty was granted to the alleged contemners to file a supplementary affidavit to the affidavit of compliance, annexing the relevant communications made by the bank to the civil CIBIL caps authorities and incorporating the necessary pleadings in respect thereof. Full stop. As a last chance to the alleged contemners, learned counsel appearing today for the alleged contemners submits on instruction that partial compliance of the order has been done. Full stop. However, partial compliance would not serve the purpose, since it is the incumbent duty of the parties to a litigation to comply with the orders of court fully. Full stop. Next para. Be that as it may, on the prayer of the alleged contemners, the time for filing supplementary affidavit is extended for a week from date. Full stop. A copy of the same shall be served within such period to the learned advocate on record for the petitioner. Full stop. The application shall next be listed on August 8, 2025. Full stop. In the event any rejoinder is sought to be filed by the petitioner against the supplementary affidavit, full stop, the same will be filed on the returnable date with an advance copy to the learned advocate for the alleged contempt. Yes, Mr. Mukherjee.
Lordship, kindly come.
Messrs. Mukherjee, actually. Messrs. Mukherjee, yes. So engrossed in your matter, you are forgetting your surname. Mr. Mukherjee, yes, complied with it appears from your.
No, Lordship, kindly come to the order. Lordship, let me.
Yes.
Lordship's order dated 1st May 2024.
That is at page 23, man.
No, internal page? Acha, is disposal granting leave apply for it? Yes, what is the contempt?
The same, including giving consideration as to whether
Suit is required.
suit is required. Now, Lordship, suit is not required because according to their affidavit, there is no question of suit. Actually, be necessary for the petitioner to get electricity connection locality and shall raise a quotation in that regard. In the event petitioner comply with all formalities and give all the.
It has reached up to what stage? They have raised the quotation?
Yes, yes.
No.
Yes, yes, yes.
They passed a reason order that we cannot give a electric connect. Kind come to the reason order they have annexed in the
Let us hear it.
opposition.
Yes.
13 তারিখের অর্ডারটা বড়ালেই তো হয়ে যাবে।
Opposition was filed in this matter.
Yes.
You are filing any reply, Mr. Mukherjee?
No.
Not right.
Achha. You don't want to file a reply?
So I will file.
Their opposition, you have stated that it has been.
Yes, Mane, kindly come to your lordship's order dated 13th of June. That is the last order.
Let me rejection order be placed, Lordship.
Let us come to 13th June first. And,
Paragraph.
oh, techno commercial feasibility.
Yes, Mane, kindly come to paragraph 5.
4 lakh, 4 lakh.
Okay. Mane, I have taken instruction.
Lordship, initially they have taken steps.
No, no, not that.
No.
They have stated that they require 4 lakhs.
They have taken the stand that I had no Lordship suite certificate, so I am not entitled to get the.
Yes, what is your instruction, Mr. Mukherjee, on that third party?
Taken instruction, there is no regulation. Only it is not in our hand, Manat. Only WBRC, if they can act, we cannot do anything. And Manat, in respect of the order.
If there is no regulation, we can pass directions.
Manat,
If there is a vacuum in the regulations, if there is no regulation either way, we understand that they have to put it at the first instance. But why no? I mean, why shouldn't that be adjusted?
Subject to correction, Manat, if Manat may allows me. Manat, this is basically the out of the contempt application, Manat. Manat, kindly see, Manat, there was a direction and there is an observation made by your lordship, the order impugned that upon compliance of all formalities. I admit that we were late in serving them.
It's not the scope of contempt. Yes, what do you say, Mr. Mukherjee?
Lordship, kindly come page 18th of the affidavit in opposition first.
We have got no enmity with his client.
Let us see if you have got enmity. We may have. We don't know. Yes, rejection.
Yes, I am
so
writing.
They have taken a decision. That was the direction.
But Lordship, kindly come to your lordship's order. Lordship, initially they are time to time they're taking different stance. Initially, they have taken the stance that I had no sweet certificate, so I am not entitled. Subsequently, Lordship, sweet certificate, the area has been declared safe.
No,
by
Mr.
the
Mukherjee, without a sweet certificate, they could not undertake an inquiry as to inspection as to whether they will be giving that. If a sweet certificate is required, if you file an application without sweet certificate, they'll not even hold an inspection for ascertaining whether connection can be given. Feasibility inspection. Now, that was their stand. Therefore, we directed them to ascertain. Now that it has been ascertained, no sweet certificate is necessary. Only then the scope comes from a feasibility inspection. They'll go and inspect and
Lordship,
see whether
kindly
it's
come
feasible.
again, Lordship's order. Kindly come.
Oh, I'm there only, yes.
Ordering portion, Lordship.
Para 8, raise the quotation. Up to that has been done.
Such application being made, the WBSCTCL shall process the same, including giving consideration as to whether sweet certificate will actually be necessary for the petitioner to get electricity in connection with the locality, and shall raise a quotation. Subsequently, after satisfaction of the sweet certificate, there is no, Lordship, the
Quotation.
there is no quotation. There should be, in terms of Lordship's order compliance, there should be a quotation.
But formalities have to be complied with. That is also there.
Even petitioner comply all formalities. Lots of formalities. I have submitted application. Every documents are submitted.
No, formality for paying up the money that we are trying to open up by. Then you have to pay 4 lakh.
No, Lordship, they have to raise the quotation.
No, we have stated that in detail, it is not techno-commercially feasible, and in respect of that, he has to pay. No, that is there.
No, you have rejected. You have not stated that you have to pay.
Yes, we have rejected because
no quotation
he has to pay. Manner, it is not techno-commercially feasible. There is no regulation manner we can help him.
No, there is a regulation which says, office order says, no, there is a regulation which says that you can reject on the ground of techno-commercial feasibility.
Yes, we can.
What is that regulation?
To get the electric
Manoj,
connection.
kindly come. Manoj, we cannot go beyond the tech. Manoj, kindly come to page 16 of my opposition.
But this point was not taken by you previously when the writ petition was heard.
My writ petition was what this was not taken because it was in respect of the whether it is it falls under this sweet category or not. That is the reason it was not taken. But we have to check whether it is a techno-commercially feasible or not. If it is not, we cannot bypass everything and give. There is in paragraph 9, it is categorically stated upon compliance of all formalities.
But Mr. Mukherjee, you have to give them an option to pay at least that amount. You cannot outright say no because under the Electricity Act, you are duty bound to give electricity supply otherwise. If you have authority over that area, you are duty bound to give electricity supply. If it's a question of money, techno-commercial, what is the meaning of commercial? It's ultimately commercial. Due to the techno aspect, you are asking that you are saying that 4 lakh will be necessary.
Why I am saying, if your lordship kindly come to your lordship's last order in paragraph 2 onwards, 13 June. If I read,
yes, that modality was you
tried every aspect, my lord. There is no other submersible pump in the vicinity also. Otherwise, we would have provided. Kindly see paragraph 3. On the query of the court, it is submitted on behalf of the alleged contender that there is no other submersible pump in the vicinity.
No, Mr. Mukherjee, the order was very clear. Order was that you had not taken this point at that point of time. And Mr. Pushenjit Mukherjee has a point in saying that now you cannot raise a new issue. I mean, sweet certificate was the only issue raised by you. Nothing else was raised by you. Oh no, at that point of time, no application had been submitted by you. Yes, Mr. Mukherjee.
That is the reason.
Oh, yes, yes. If no application was filed at that point of
Kindly
time.
come paragraph 3, by virtue of a communication to another applicant, which was been
Come to
annexed.
paragraph 4, Mr. Mukherjee. After that, 4 is after 3.
Yes. Learned counsel appearing for the West Bengal WBSCTCL submits that no application was made, submitted as such writ petition.
Yes,
is
we held
ineligible.
that. Para 5 you have stated it does not appear that you have applied. No application was formally filed. If an application was filed, then
Submitted, they refuse their
this is a fresh cause of action.
file application.
Kindly see,
Fresh cause of action.
kindly see paragraph 6 there.
Seen. Mr. Mukherjee, this is a fresh cause of action. You take it up before the writ court, you may have some point there. Learned counsel appearing for the petitioner submits that in defiance of the order dated May 1, 2024,
Let there be whatever the quotation charges, let there be quotation be raised.
May 1, 2024, passed in WPA 11795 of 2024, comma, the alleged contemptor has not raised a quotation, comma, despite it being ascertained that no SWID SWID certificate being necessary in the locality. Full stop. Next para, learned counsel takes the court through the order dated May 1, 2024, where it was observed that leave was given to the petitioners to apply for electricity connection in proper format, and upon such application being made, comma, the same was to be processed by the WBSEDCL, including giving consideration as to whether a SWID SWID block A certificate would be necessary to get such connection, and raise a quotation in that regard. Full stop. Next para. It was further observed in the order that in the event the petitioners comply with all formalities, the WBSEDCL shall give the connection to the petitioners as expeditiously as possible. Full stop. Next parallel, counsel for the alleged contemptor submits that in compliance of the order, comma, it was considered whether a SWID certificate is necessary. Full stop. Upon it having been ascertained that no such certificate was necessary, comma, the application filed by the petitioner was entertained and an inquiry undertaken, an inspection undertaken, upon which it was found that the connection, that giving electricity connection to the petitioner was not techno-commercially feasible. Full stop. Next para, learned counsel relies on an office order bearing number EDD/75 dated September 30, 2024 in that regard. Full stop. Accordingly, comma, it is submitted, comma, the application of the petitioner was rejected
September 30,
and it was communicated on April 7, 2025. What did I say? Accordingly communicated to the petitioner by an
No, not communicated.
তোমরা পাঠিয়েছি তো দিয়েছি তো
But this is
কি বললাম, কোন জায়গাটা বললাম, মাঝখানে ডিস্টার্ব করলে ভীষণ অসুবিধা হয়। না, and it was communicated, rejected VIDE memo number PKR sub block A, PKR/CCC/ establishment a short form, capital ESTB/19 dated April 7, 2025. Full stop. In the said rejection order, comma, it was recorded that after careful inspection and subsequent estimation, comma, it has been determined that the total cost of the proposed scheme amounts to rupees 4,08,301.03 small p. Full stop. On such ground, comma, the application was rejected on the ground of techno-commercial feasibility. Full stop. Next para. Upon a consideration of the order under contempt, comma, it is seen that this court had observed that there was nothing on record to show that an application for electricity connection had, comma, at that stage, comma, been formally filed by the petitioners. Full stop. As such, comma, liberty was given to the petitioners to file such application in appropriate format, comma, on the observation that it would be premature for the writ court to interfere in view of there being no application. Full stop. Next para. While passing that order, comma, it was further recorded that in the event a proper application was made, comma, the WBSEDCL shall consider whether a SWID certificate was necessary, and in the event it was not so required, comma, shall raise a quotation. Full stop. Next para. However, comma, as it transpires, comma, upon such application being made, comma, it was found that the electricity connection being given is not permissible under the office orders and regulations of the WBACDCL, in view of the connection not being techno-commercially viable. Full stop. Next para. The argument of the petitioner that there is a contempt of the court is not tenable, since the writ court itself had observed that at that juncture there was no pending application and there could not have been any adjudication in that regard. Full stop. Next para. In any event, in the present case, since no suite certificate was necessary, the application for electricity connection of the petitioners was accepted and an inspection held, upon which it was found by the WBACDCL that such connection was not techno-commercially feasible. Full stop. It was also indicated in the said order rejecting such application that the cost of the proposed scheme would amount to rupees 4,08,301.03. Full stop. Next para. Although strictly speaking, the WBACTCL ought to have raised a quotation in respect of such amount instead of rejecting the application of the petitioners outright, this court is of the opinion that there has been no contempt as such of such a nature that the alleged contemptor should be penalized. Full stop. However, it is made clear that if the petitioners are willing to pay the amount of rupees 4,08,301.03, the petitioner shall approach the WBACTCL in writing with such proposal. Full stop. In such event, the WBACTCL shall consider whether the electricity connection can be given to the petitioner. Full stop. Next para. However, the above observations are without prejudice to the rights and contentions of the parties in the event the petitioners, being aggrieved by the fresh action of the WBACTCL in rejecting the petitioner's application on the ground of techno-commercial feasibility, prefers a challenge against the same before the appropriate forum. Full stop. If any such challenge is preferred, it will be open to the forum/court taking up the same to independently adjudicate the same without being prejudiced in any manner by any of the observations made in connection with the contempt application. Full stop. Next para. CPAN 71 of 2025 is thus disposed of with liberty to the petitioners to challenge the rejection of the petitioner's application for electricity connection on the ground of techno-commercial feasibility before the appropriate forum/court. No address to cost.
I'm
Next.
grateful, Manad.
Thank you.
And I'm sorry, Manad, I
No,
disturbed. Manad.
you should, in these cases, why don't you raise a quotation of that amount? It's an exorbitant amount, but if they don't, then they have a right to challenge. We have given that challenge but they had to file a contempt for that.
And I'm sorry, Manad, I interfered, Manad.
No. Next.
I'm grateful, Manad.
Thank you.
I appear for the petitioner. Lordship, this is a contempt application appearing for the first time.
What is the nature of contempt, Mr. Ali?
Nature of contempt, Lordship, will kindly see the order at page 367. The Board of Worker was to consider the irregularities and illegalities committed by the present Matwali and take appropriate.
Page what?
Page 367 is the second volume. Alert.
Yes.
367, page 108. Lordship.
Board of Awqaf was directed to.
My revisional application was allowed. The impugn order was set aside. And
What was the resolution which was set aside, Mr. Ali?
Lordship, by which, Lordship, there was a resolution by
accepting a scheme.
Accepting a scheme for development of a property.
You challenge that acceptance?
I challenge that.
What have they done now?
No, nothing, my lord. I have given 2 notices, page 368, and thereafter, my lord, there is another, 3 notices.
So they have to immediately look into the alleged irregularities. That has not been done.
Not been done, my lord.
Yes.
Only one more thing, my lord. The contemner has changed. The incumbent has changed. Lordship, may I
Changed.
Has
So
a
we'll
new
give you
incumbent-
liberty, incorporate the new name and
incorporate the name. Lordship will grant that liberty, and Lordship asked me to serve.
very
my
well,
lord.
very well. A prima facie case of contempt has been made out inasmuch as, in violation of the judgment and order dated September 21, 2021, passed in CO number 200 of 2021, the alleged contemner has apparently not looked into the alleged irregularities and illegalities committed by the present Matwalis and taken appropriate steps in that regard. Full stop. Next para. Learned counsel for the petitioner submits that in the meantime, the named alleged contemner has demitted office and a new incumbent has come in. Full stop. Accordingly, on the prayer of the petitioners, leave is granted to the learned advocate on record for the petitioners to carry out the necessary amendment to the cause title of the contempt application by incorporating the name of the current incumbent to the post of the alleged contemner in the cause title of the contempt application. Full stop. The petitioners shall serve a copy of the contempt application on the alleged contemner, indicating that the same will be listed next on August 22, 2025, under the same heading, when an affidavit of service in that regard shall be filed by the petitioners. But don't delete the name of the earlier contempt, because he was in office when it happened.
Yes.
Shall serve a copy on the alleged contemner, bolam na? On the alleged contemner,
তাহলে দুটোর হবে।
as well as the newly added contemner. Serve on both. Retain the previous one on record, because during a certain period he also did not comply.
বুঝতে পেরেছো?
Just by demitting office, people are going scot-free. I mean, we should not allow that.
Grateful.
Thank you.
But I am for the petitioner in these two
Yes.
applications.
Your Lordship,
I have served the
Kushal Chatterjee is
Happening for the first time.
for the first time. These are applications for modification of your Lordship's order dated.
Your Lordship, I'm seeking more time because Mr. Kushal
Wait.
Chatterjee is appearing.
Affidavit of service, there was a direction for service.
No, no, it is application for modification.
not
It is not
contempt.
contempt.
Achha, yes, you are for the respondent.
Your Lordship, as far as the instruction is concerned, originally I was
Please use a microphone.
because originally I was the petitioner in this application.
Now you are the
Opposite party number 2, Mr. Kushal Chatterjee is appearing. Due to some personal difficulties, he is out of town. I'm
Who?
seeking Mr. Kushal Chatterjee, Your Lordship.
Kushal Chatterjee.
Your Lordship.
You're his junior.
Your Lordship, I'm been instructed by his clerk.
Very well. So, yes.
Sit not today, Your Lordship.
Not today means 2 weeks after, because we don't have, we are out of town. We'll be holding circuit in Jalpaiguri.
The only difficulty, my lord,
Yes.
client's business is closed absolutely because of the acts of
Whatever
the
you say.
parties. That is the difficulty. Otherwise, I wouldn't have.
Modification, generally Mr. Chatterjee does not ask for time. So, what can we?
Already
Learned counsel, affidavits, why 2 affidavits?
No, 2 applications are there, 26. and
Affidavits
27.
of service filed to be kept on record. Full stop. Learned counsel, an adjournment is sought on behalf of the revisionist petitioners stroke present opposite parties on the ground of absence of learned counsel appearing for the said parties. Full stop. Learned counsel for the opposite parties in the revisional application and present applicants submits that there is extreme urgency involved since the business of the applicants is now closed by virtue of the order of which modification has been sought. For the next para, in view of the prayer of the opposite parties to the present application, the matter is adjourned till August 8, 2025. For stop, however, it is made clear that in the event the opposite parties in the present application seek further adjournment or remain absent, ex parte orders may be passed in their absence in connection with the modification application.
Deeply obliged.
You give your name, please, just only your name. Yes.
My lord, I am for the petitioner. My
reply to the petitioner's contention this matter.
You have to give the reply.
I'm the opposite party
Yes,
respondent in this matter.
Mr. Rai had been arguing on the last.
yes, my lord, he is engaged at courtroom number 551.
He had finished arguments. He was
Yes, my lord.
Yes.
Lord, two major points that has been argued before your lordship, Lord, with respect to Lord registration of the apartment ownership, one being barred by limitation.
Is the gentleman beside you an advocate, ma'am? Is the gentleman beside you an advocate?
My lord.
He's not an advocate. Very well. Yes.
Lord, two things have been primarily.
Take the microphone up. Yes.
Lord, two things have been primarily argued. First is with respect to my application.
Is it on?
But am I audible now?
Yes, yes. That was. ওইটা মাইক্রোফোনটা একটু দেখিয়ে নেবেন তো, ওটাতে রোজই প্রবলেম হচ্ছে, ঢুকলে হচ্ছে কথা বলে শোনা যাচ্ছে না।
Yes, Lord, am I audible?
Yes.
Yes, now Lord, two things have been argued. First is with respect to my application being barred by limitation because of Lord Rule 2A, and the other aspect is Lord, they were not heard. These were the two primary arguments with respect to this Lord.
Yes.
Lord, the first thing I had argued before, I had submitted before your lordship, rather, Lord. Yes. And the first thing that I had submitted before your lordship on the last occasion was with respect to Lord limitation aspect. Lord, provisions of Lord the Apartment Ownership Act, Lord says.
Yes, you continue.
Says
more or less remembered. Yes.
3 years from the date of completion certificate.
Yes, completion.
Lord,
there was an argument whether it was a completion.
Lord, I had Lord indicated from Lord the municipal laws as well as Lord from the Apartment Ownership Act also. Lord, that and RERA rules. Lord, that there is a substantial difference between Lord occupation certificate and Lord completion certificate.
Yes.
Lord, despite the term.
Notes ছিল না? এটা নোটস ছিল না? দেখুন তো। এখানে right. Please continue. Yes. RERA rules and there's those.
Yes, I'm shown your lordship, Lord, the West Bengal RERA Act, the West Bengal RERA rules, West Bengal Municipal Act, as well as Lord the building rules of 2007 to Lord demonstrate that Lord the legislature has consistently Lord distinguished the two terms. One is occupation certificate, the other one is completion certificate, and the purpose of granting, the two difference between purpose of granting.
নতুন আনিয়ে নিন 2019 এর পর চেঞ্জ চলে এসেছে, এখন আনিয়ে নিন শুনতে continue.
So Lord, taking that into consideration, when the latest of the amendments in 1972 Act, Lord, only indicates completion certificate and not occupation certificate, Lord, then in such a situation, the limitation would commence only from the date of issuance of completion certificate. Today, admittedly, Lord, there is no completion certificate with respect to this project.
You argued something of the sort that the entire building, unless the entire building is concluded, there cannot be any
occupation charge was not devised. Occupation Lord certificate was devised for the reason of these large projects.
Large project, only one tower suppose came up.
Occupation certificate, next building occupation certificate, total completion certificate.
Very well.
That was the argument.
So unless that is done, it cannot start.
It will not start. So Lord, that is my answer. Lord, I'll not repeat your lordship.
No, need not repeat. But Mr. Kormaka, tell us this. Then, in your opinion, I mean,
my lord.
Then, if the entire project is not completed,
my lord,
then there cannot be any registration under this act.
There is no requirement, but I can.
Very well.
Lord, this act is completely optional. Whether I will opt for
choose, you can choose.
Yes. So Lord,
by filing that.
Yes. Right. So Lord, but this act puts a restriction that once the completion certificate is there, after 3 years, you cannot apply.
So there is no time bar. There is a mandate.
Absolutely.
Very well.
So Lord, at least in my case, for this case, had it been a situation that completion certificate was granted and there
yes, obviously
different. Now, Lord, that is my answer. Lord, I will not repeat. Your lordship have already taken note of Lord. Now, the second aspect of the matter will notice to them. Now, Lord, for this, I must be candid before your lordship, Lord. In other judgments,
you have to be candid because otherwise,
Lord,
you don't have a point.
Lord, in other judgments,
you cannot give notice to yourself. You file the application and the notice is given to you.
Lord, that is perhaps not your lordship has held.
That would be an absurd interpretation.
Lord, perhaps not. Lord, the reason is, Lord, I've gone through, Lord, the other apartment ownership acts also.
Other states.
Other
No,
states.
this is West Bengal. Yes.
This is West Bengal, other states. Some of the states, Lord, contemplate of a situation where adjudication is required or a decision or a finding by the authority is required whether this particular, Lord, association will fall within this act or not. Other states say that there is no adjudication required. It's a matter of, Lord, ministerial job. You file it, it gets registered. Lord, I shall place those, Lord, just to show, Lord, the footing is same. When 1972 Act was introduced, Lord, there was no provision for this notice of parties. It was also similar to, Lord, the all other prevailing, Lord, state acts. 1992, Lord, this particular phrase was incorporated. 1992 amendment of the 72 Act incorporated this particular phrase for the first time. Lord, may I place that for first, but thereafter I take
If you say that, then by necessary implication from 1992, the intention of the legislature was clear that now an adjudication is required.
That is exactly what I'll show from the statements of objects, that the requirement of the legislature was the persons who did not want to participate or wanted to be a spanner in the wheel to exclude them and proceed with the registration.
That's why a notice is required.
Notice is required to the parties. Parties in a proceeding or in an adjudication process are persons who come to submit themselves.
How do they know that an application has been filed? That's why the notice is required.
The notice of knowing is Form E. Form E is there notifying that this property is going to be the subject matter of Apartment Ownership Act. Whoever wants to come or oppose.
Karmaka, we are not on the forms. A notice has to be given under the provision.
That is the notice required prior to submission. Once the submission is complete,
let us come to that provision.
Yes.
That was the rules of the.
Not section 10A.
Subsection 2.
After issuing notice to the parties concerned, had it been the case what my learned senior friend is arguing, that not all the apartment owners were required to be served, not apartment owner is defined in this act, and from the other provisions also, I shall demonstrate that not specifically apartment owners have been used. When the legislature, after Milord including this phrase by way of an amendment, Milord chooses the word notice to parties concerned, then Milord a meaningful reading has to be given, Milord, to the word notice to the parties concerned. Else, the legislature should have used, Milord, apartment owners. All apartment.
Mr. It's wider than apartment owners then.
My lord.
We have to consider on a wider basis. If it's not apartment owners, intention was apartment owners and any other person concerned. Because why we say this, otherwise, what is the absurdity?
My lord.
If it was not so, then no notice would be required. Then it would be on receipt, would be on receipt of a declaration or an amendment thereto or an instrument referred to in 1, competent authority shall, after holding inquiry, examine the declaration and do it.
That was.
Then what is the requirement of the
what is my lord saying? That was the 72
Precisely. After issuing notice, why is that introduced at all into the act?
That is required.
They would be no necessary for it would be a superfluous thing.
That is required. The reason is the limited scope of.
I file the declaration.
My lord.
The competent authority just decides it upon its own inquiry.
That was the course.
It's over. Now, if an issuance of a notice is incorporated, that obviously means that all persons concerned have to be given notice.
But all persons.
That cannot be only you. Then it would be the applicant.
But all persons concerned does not might not mean only the applicants. The reason is persons who come after Form E.
Not only the applicants.
Not only applicants.
Yes, the others also.
After Form E. Suppose, for example, Milord, two people or majority of the people apply.
No, what is Form E? Form E means a notice to all who?
Not kindly.
To all the apartment owners.
Take your lordship to that.
Form E is under Form E is under which rule?
Milord, I shall take your lordship. Kindly grants me 1 minute's time, Milord. Lord, kindly comes to Rule 6.
Yes.
Lord, Rule 6. The instrument referred to such and such shall be executed Form C within 30 days from such and such, be signed after completion. 10A, may prefer. No, no, form এটা তো ওইটা rule 6.
Form B speaks about 10A, section 10A 1.
Lord, kindly comes to Form E of that rules. Lord, that's the after Form D.
After Form?
After Form D, Lord, Your Lordship, it's the part of the Lord Act, the rule rather. Intention, my Lord, kindly got it, Lord?
Form?
E.
E, yes, intentions.
Intentions of notice to submit the property under the provisions of such and such to all concerned, whoever are the parties, submission of our property situated at such and such.
This is under Rule 4, Rule 6, which is in turn under Rule Section 4.
Yes.
So on a different footing altogether.
This is
Section 4 is something
this
else.
requirement is prior to submission of the property to this Lord, particular authority or act.
Have you seen Section 4.3? Rule 6 itself is under Section 4.3.
My Lord.
B2. Section 4.3 B2 is notwithstanding anything, but any person taking lease or for a period of 30 years, taking lease or apartment comprising a property, execute and register an instrument. It is for the purpose of taking lease. For that, Rule 6 itself is under Section 4, that provision. And Form E says it's under Rule 6. It's on a different footing altogether. So, Mr. Rai, no.
Form E provision.
Lord,
it's under a
Lord,
different provision.
There is some mistake, Lord, in I should have, Lord, indicated. Lord, kindly comes to Rule 3 once.
Rule
kindly
3?
comes to Rule 3.
Yes.
আমি এটাই কিছু পাচ্ছি না।
Rule 3, yes.
The declaration under Section 2 by sole owner of such and such of the majority owners case may be of a property shall be executed in Form A to be signed such and such. 1A, now that was introduced in 2016 after the judgment, Lord. In case where majority of the owners intend to submit declaration under Section 2 in Form A, they shall give notice of their such intentions to all the remaining owners in Form E. So, Lord, that Form 6, Rule 6, perhaps, Lord, is a, Lord, I do not know.
Rule 6 is entirely different.
Yeah, that's different. That does not relate. Form E is basically under this rule. Rule 3(1)(a). Under this rule, Form E is required. So, Lord, prior to submission of this any property before this act, Form E is required. It's a notice to all. One who avails this notice becomes a party concerned. That's my respectful submission, Lord, for your Lordship's kind consideration. Else, Lord, because your Lordship would find from the other part, Lord, of the Act, everywhere where all the apartments owner are meant, the Act consciously used the term, Lord, apartment owners.
So 10A1 says that notice of intention.
My Lord.
Rule 1A, 3(1)(a), Rule 3(1)(a), which you placed.
My Lord.
Rule 3 itself is Section 10 capital A also.
Yes.
So Section 10 capital A1 says any declarations shall in the first instance be submitted within 30 days from the date of execution to the competent authority along with copies of cited and the notice of intention to submit the property to the
Yes.
provisions of this act
My lord.
by the majority of owners to the remaining owners of the property in such form
Yes.
as may be prescribed when such declaration is made by majority of owners.
My
So it's a majority of owners. They have to give a notice
to all.
of intention to all,
All.
which will be under this Form E.
I'm grateful.
So you say that was given in this case, your
Yes,
case.
that was given in this case. I shall show that. That was given in this case.
You gave a notice to all the owners
My lord, I show your lordship, lord.
of your intention
Kindly
to
comes
submit.
209. Eta page 209 of আমার অপর affidavit. Read petition. Lord, kindly comes to the read petition, page 209.
Two zero nine.
209, Lord of, I'm sorry, Lord of 8125, WP 8125.
আচ্ছা, two zero nine, yes.
Now, this is Form E. Kindly seize the date 24th of March 2022, much prior, Milord, to the date of submission.
Where is the proof of
To all
service?
flat owners, this was the notice, Milord, on the notice board. It was pasted.
In their affidavit in opposition, how do they deal with it?
They have annexed. It is their petition.
Right.
They have annexed it.
Yes.
So, Milord, the notice was there. Now they say after this notice also, the authorities ought to have given them notice under, Milord, that particular subsection. Lord, I say,
What would be the meaning of 10A2 then?
Lord, 10A2 is only with respect to parties concerned. Now, Milord, may I just indicate to your lordship?
Parties concerned cannot be the declarants themselves. Then it would be said declarants.
Lord, declarants
And
any parties who come or try to come under Form E, after Form E.
all right.
One who tries to submit to the jurisdiction of the authority. Lord, kindly seize with this respect, Lord,
Give us half a second.
the, sorry. না সাইটেশন না আসবে সাইটে ঠিকই আছে
So you say, Mr. Gormokar, the chronology would be Section 10A1 read with Rule 3IA 1A read with Form E. That notice has to be given expressing the intention to submit a form. That has to be given to all the owners.
My lord.
Once the notice is given,
My lord.
then it is submitted. Authority now will give notice to only those persons who respond to that Form E and approach and come forward to the authority and express that they have something to say. They are the persons concerned.
Absolutely.
All right.
The reason is that I'll come, Milord. The reason is only to the limited extent of, Milord, adjudication that the authority exercises. The authority is not a court. It exercises, Milord, only a limited jurisdiction as regards whether the papers are correct.
So limited jurisdiction argument is not probably, does not make a difference, because even if the persons concerned come after getting in, theoretically all can come.
Yes.
So then also there will be a question of adjudication.
Initially,
That notice would be
initially, before this majority concept came in, after, Milord, this judgment of our
Yes.
High Court, and thereafter, Milord, this amendment was carried out, either single owner or all had to come.
Yes.
Just to drive that away, this majority concept was
yes.
brought. Now, Milord, to
No, we say, what I am saying is you are arguing that this hearing on merits need not be given. So scope of adjudication is limited. That argument does not make a difference, because even if those responders to the for me notice come, some adjudication has to be given to them.
With respect to not only
So
verification
that does not have any effect on 10A2.
No, let us not for the
Whatever is the scope of adjudication, we are
not
considering what is the person's concerned. What is the meaning of person's
Fine.
concerned?
Lord, with respect to this, may I rely on Lord Black's Law Dictionary? Lord, kindly turn.
খুব ভালো, খুব ভালো, খুব ঠিক আছে। এটা অনেক নতুন। এটা ফেরত পাঠিয়ে দেবেন একদম। Yes, Black's law, what does it say?
Lord, kindly turns over party. Lord,
Yes,
top,
party.
Top party. A person concerned or having or taking part in any affair, matter, transaction, or proceeding considered individually. A party to an action is a person whose name is designated on record as plaintiff or defendant. Term in general means one having right to control proceedings, to make defense, to adduce or cross-examine such and such. Party is a technical word having a precise meaning in legal parlance. It refers to those by or against whom a legal suit is brought, whether in law or in equity, the party, plaintiff, such and such, so on and so forth. Now, my lord, this is only to show that my lord, party concerned will necessarily mean a person who has submitted my lord, to the jurisdiction of an adjudicating authority. The same meaning, my lord, your lordship would also find in my lord, another dictionary of Lord.
No, the language of this section is not party, it's person.
Party concerned. Party is concerned. Notice to the party
person.
is concerned. Not person concerned. Party is concerned.
All right.
Now, my lord, kindly takes this, my lord, Mitro's, my lord, legal dictionary.
Closer to home. Yes. Party.
Lord, kindly turns over the first page, my lord, party. A person or a group of persons participating in an action, transaction, deed, dispute, or contest. So, my lord, again, the involvement has to be there. Now, my lord, from the act itself,
And you may also argue that why a double notice? Already I am giving a notice to all right.
my lord, kindly now comes to the act again. Section 3, my lord, 1IA, rather 3IA.
Yes.
The definition of owner is given. Your lordship would not find from the definition some party or parties concerned is given. Owner's definition is there. Now,
Owner will not use
this?
party.
Yes, why I am placing this? Now, my lord, kindly one after the other.
How can owner use a party?
Yes,
that would be entirely
but I'll
ridiculous.
place the provisions, my lord. Kindly, my lord, kindly first comes to section 5. Section 5(1). Each apartment owner. Section 5(4). Each apartment owner may use. Again, my lord, your lordship would find 6. The association of apartment owners. Turns over, my lord.
6 is each apartment owner.
Yes. apartment owner. But that's exactly what I'm not trying to demonstrate with your lordship. Wherever the act wants all the apartment owners to be included, the expression apartment owner or each apartment owner is being used. But I'll just indicate the provisions further. Lord, section 5 capital A3.
Yes.
Lord, thereafter your lordship would find Lord, section 6.
Yes.
Section 7. Lord, kindly sees the wordings of section 7 also. No apartment owner shall do.
So statute uses apartment owner where it wants.
Yes. When it requires.
So you
Section
have
9.
something closer home. I mean, section 10 capital A1 itself says that notice of intention to the remaining owners of the property. So if you come to subsection 1, it says owners, whereas 2 says parties concerned.
I was taking a lordship one after the
No,
other.
the rest of the statute may or may not be relevant because that may be in a different context. But if the same section uses two expression for two notices, then you may have a better
That
case.
would have been my next submission, Lord.
Yes.
Consciously, the legislature uses this Lord expression. And after this also, Lord, your lordship, section 13.
I think personally that the indication in the section itself is better to use, to look at, because two subsections speak of notices.
My lord.
One says remaining owners, the other says
Parties concerned.
Parties concerned.
Parties concerned. Now, Lord, for further, Lord, Lord, for further argument, Lord, or submission rather, Lord, in this regard, Lord, may I place the amendment for which this was brought in?
The previous portion is here. The object of the amendments.
Yes. Lord, kindly turns to Lord the second last page. The original version your lordship would find in the book itself, Lord, that the parties concerned was not there. What your lordship, Lord, indicated.
Second last page is the act itself, not the amendment.
Lord,
Statement
second
of
last
object.
page, Lord, statement of objects and reasons.
This is for the amendment.
Yes.
Achha. Yes, right.
This is part of this, Lord. Was not readily available.
No.
The West Bengal Apartment Ownership Act 1972 was passed by the state legislature and assented to by the President in 1972, and the provisions thereof were made applicable.
Give a copy to your learned friend. Because you're relying on something which may not be readily available, as you said.
Thereof were made applicable with effect from the 7th June such and such. The application of the Act as per the existing provisions is optional on the choice of the sole owner or all the owners of the property. Such application of the Act in fact stood in the way of achieving the intended objectives to the desired extent. Availability of land being extremely limited and need for additional housing stock being increasingly felt, the only option left is for the multi-storied buildings with apartments, flats. The application of the Act depending on the choice of the sole owner or all the owners.
Quite obvious, quite obvious.
As in many cases in the past, obstructed the majority of the apartment owners from getting the benefits of the Act whenever even a small minority of such owners had chosen to opt out of the same. Proper management, maintenance and upkeep of the housing stock cannot be overlooked. The application of the Act providing the means therefore has therefore been felt all the more necessary. In the backdrop of all these facts and circumstances, compulsory application of the Act appears to be the only choice.
Your argument can cut both ways. Why we say this? Yes, obviously either sole or all. That is a
at that point of time.
That is a stark choice. I mean, somewhere in between there is no balance. I mean, majority may want, but minority may resist that.
Yes.
Right. For that it was brought in. But if you draw this into the act itself, probably you are trying to insinuate that that means now the majority owners, the intention of the amendment is that majority owners will have their say and they can have this declaration.
Now, and the furthermore
But
thing
that
is
does not mean
call out
to
the
call out the
person
minority resistance.
who did not want to.
But Mr. Kormokar, this operates at the level of seeking a declaration. Now, previously, either sole one owner, if he was the owner, or if there were several, then all had to come.
All had.
Let us forget sole owner. All had to come.
My lord.
Now, majority can also come.
My lord.
But for that precise reason, the other argument, the contrary argument will be, because of that, because that right is now being given to the majority, they can even apply. The minority has to have the resistance, lack of resistance does not mean they'll be effaced, they'll be obliterated. They won't have any say just because they have they are in a minority.
Perhaps that
No,
the,
all the more reason to give them a hearing, Mr. Kormokar.
perhaps not that is the reason. Not
And that has been recognized in 10A1 also.
not
So
perhaps
the remaining owners have to be served a notice.
10A1 has not come at a stage not prior to this.
Oh.
10A was introduced prior to this because 10A was amended by this Amendment Act. At that portion, at that situation, either sole or majority, or either sole or all the owners were.
NA1 previously did not require a notice to the remaining owners. Yes. But now it is required.
92.
So therefore, the majority being given a choice does not mean you efface, you obliterate the minority. You don't hear them, smash them. No.
May I clarify? May I clarify further?
10.1 has been introduced by this same amendment. Not
10
that prior amendment.
Yes.
Acha, 2015 amendment.
Lord, I shall, yes. No, 2015. No. Lord, this is kindly comes to Lord,
17,
Section
12,
6 of this Act. Section 6 of this Act. The third page.
Yes.
10A was existing. 10A was sought to be amended only to the issue of after holding such inquiry. Instead of that, introduction was after issuing notice to the parties concerned and after.
In the book, the entire section, say 10A, previous 10.1 is given. That 10.1 says that does not contemplate any notice. That said, any declaration referred to in such and such shall in the first instance be submitted in duplicate within 15 days to competent authority along with copy, site plan, building plan, relevant title deeds for purchase of or agreement for lease. Bas, submitted.
Yes.
This much. So no notice was required to be given to the other owners.
That is exactly what I'm trying.
That was brought in after 1992, the remaining owners.
I'll tell you, Lordship. Initially, when the 72 Act was promulgated, the situation was either sole owner or all the owners. After that, 10A was introduced, the process of how to apply. In the previous 10A, the situation was also for sole owner or all the owners. The concept of majority owner for the first time was brought in this Act in 2015. In 2015. So, Lord, this notice to parties concerned was introduced much prior to the concept of
15 or 92. This is the object statement of object of the 92
that
bill.
Act does not bring in the concept of majority owners.
The statement of object of reason says that.
Yes, that is what I'm trying to impress upon your Lordship.
This is the 1992 statement of object and reason.
Look, this statement of object and reasons was at a time when the concept of majority owner was absent in this Act. But
so in 1992, that concept was sought to be brought in.
That concept was sought to be brought in without making any amendment with respect to majority owners being introduced.
Yes.
This majority owner formally got introduced because of a
introduced when 1992.
2015.
Acha. But 1992, why does
kindly takes up
90 book? The statement of object and reasons of 1992 speak about majority owners who should be given, but it was not brought in 1992.
1992.
Then this statement of object and reason is contrary to the 1992 amendment.
Is required. Why? This concept of majority owners was put in this Act by virtue of this notice to parties concerned.
1992 Act does not bring that in.
Lord, 1992 Act brings that in only to the restrictive nature of notice to the parties concerned. That means majority persons.
into A2.
Yes.
Acha.
Notice to the parties concerned, the concept was introduced. Subsequently,
Therefore,
my lord,
according to you, Mr. Kormakar,
my lord,
it is all the more that 1992 Act says the statement of object and reason says majority owners have to be given a say. But majority owners were not permitted then also by that amendment to apply.
yes, all had to apply. No, that's why the
majority were not given right to
Yes,
apply by the
yes,
92 amendment.
yes,
But it was held that majority owners should have a say.
yes.
In that context, you say 10A2 was amended.
Amended for parties concerned.
For parties concerned. Then
Notice,
what would
only
that mean?
notice.
What would that mean?
No, that would mean that parties concerned,
That still all the owners had to apply.
the persons who were submitting, that was contrary at that point of time. That became the plinth of our judgment.
Right.
That became the plinth of our honorable court's
Our court's
judgment. To hold that
there was a
particular-
inconsistency.
Yes, particular portion of this act to be ultra vires. That's resulted in 2015's amendment.
Yes.
To save that. That's the basis. So, my lord, if that is the basis and, my lord, the background,
So
my lord,
therefore,
does it
which
lie?
portion was held to be at ultra-virus?
Lord, that all had to
All
apply.
had to be.
All had to apply.
So now majority comes in.
Majority comes in. That was
But
in
2A
line.
remains.
2A remains.
I mean,
2A
10A2 remains.
2 remains. My lord, 10A2 remains along with the introduction of majority where owners is used and the notice to the parties concerned remains the same.
But 10.2 was inconsistent.
Lord,
That is
why I indicated to your lordship the statement of object and reason, the basis was that at that point of time also the reason of bringing in is the persons who did not want to come in had to be obliterated. Persons who were creating problem, they had to be
statement of
obliterated.
object and reasons seems to be entirely inconsistent with the amendment itself.
Lord, kindly consider
persons concerned. If all have to apply, who is the person concerned?
The party is concerned. I had indicated, the meaning of parties.
Who are they? If all had to apply?
Lord, that was the problem. At all had to apply in a situation.
You are relying on section 10A2, the amendment of 1992, to say that that is a reflection of the majority concept which first came in. But the inconsistency was that, Mr. Kormakar, for which 10.1 was amended, 10A1 was amended.
No, that's the more of a reason why
10A2. There was no party concerned other than all the owners. If all the owners apply, who would be then the party concerned?
Lord,
apart from them?
Lord, it is only for that clog, to stop that clog, that all the parties, if did not want to apply, the person.
How does this help you? Majority owners is still the concept.
Lord,
now it has been brought in.
Yes.
So how does that help you
Lord,
in
that
this
is
your argument?
Lord, that is exactly what I'm trying to impress upon your lordship, Lord. That in 1992 also, to stop this clog of this minority, this introduction of notice to parties concerned, that is the majority came into
stopping clog, Mr. Kormakar, it's an absolutely autocratic interpretation which you are asking the court to take. Why autocratic? You are saying that previously either all or one, all had to apply together. What was the clog? The clog, so-called clog, as per your argument, is that even if majority owners wanted, majority will would not be sub-served. But majority will, just as in a democracy, Mr. Kormakar, cannot mean that the resistance of the minority would be altogether deleted, erased. No, not that. Majority will now have a right to apply. Majority, previously, even majority wanted, they could not apply even. All had to either all or none. Now majority can apply to safeguard the interests of the minority. That does not mean if the majority applies, they will automatically get it. No, then there would not be any reason for giving further notice under 10A2. The notice, then the notice would have to be given to the persons who applied to themselves, like the plaintiff being given the summons of a suit.
That could have been a situation if
who would be the persons concerned, parties concerned? The applicants themselves.
That could have been a situation, provided that
that is the check and balance in respect of the minorities. Now, not all majority can apply. But the minority will have a say because a notice, and that is recognized by 10.1 also, 10A1 also,
10
which says for me has to be given.
10.1A rather, not 10
Says that notice has to be given to the minority.
Form E.
So they are not shut out.
Under Form E, now one who does not come in.
That is something you are introducing into the statute, which has not been enumerated. Some words have to be introduced by the court to the statute, which is deprecated time and again.
So that is
that we cannot introduce words read words into the
so
statute.
that is in the statute. Lord, I am only trying to demonstrate and explain, Lord, what the statute means. Lord, that could have been the situation if, Lord, the position was pre-2015. Post
1992 amendment does not help you much.
Post 2015
Statement of object and
Lord, post 2015, Lord, kindly considers this. Post 2015, if the amendment has been carried out and consciously, Lord, that sole owner, apartment owner, these words have been used in the statute. In such a situation where the legislature thought it fit not to use that apartment owner again in that 10A2, Lord, does the second notice is required? Lord, my respectful submission, perhaps no. Perhaps no.
Yes, that is a good argument. It would be redundant, a second notice to the same person.
Because the purpose is lost. Once form is there.
Mr. Kormokar, if a section 80 is notice is given to an authority, suit is filed.
My lord.
No summons is required to be served further to the respondent authorities. Then on the basis of that section 80 notice, the suit can be decided.
Section 80 notice perhaps, Lord, is on a subject to my understanding, Lord. Section 80 notice is completely on
I'll file a suit.
Footing. The reason is, Lord, Section 80 notice is a step to permit the government to take steps so that the remedial measures can be taken so that the
Section 80 is a notice of a suit.
Yes.
That I am going to file a suit.
Yes.
So you give notice of a suit, then again why serve summons?
Lord, I tell you, Lordship, Lord, Section 80's purpose, what I have understood is, Lord, to give a notice to the government to take remedial measures because this suit is going to be filed. Unnecessary litigation the government might
Whatever,
not
for remedial measure or
this,
otherwise.
so that he can take that measure.
Maybe, but they have knowledge all the same.
No, knowledge of the
that
dispute.
gives knowledge of the file going to be that I am going to file a suit.
Lord, knowledge of a dispute, not knowledge of the suit. This is a dispute where suit is going to be filed. Lord, kindly see, Lord, Section 81.
No, no.
And Lord, the usage of the term is also different.
No, no.
No suit shall be instituted against the government.
That is a notice of the suit delivered to his office stating the cause of action, name, description, place of residence of the plaintiff and relief which he claims. And the plaint shall contain a statement that such a notice. Therefore, it's a notice of the suit. Now then, why serve a notice? Why serve a summons against?
Suit
Again,
the suit has been filed.
Because Mr. Kormokar, the difficulty would be I circulated for me notice that see I am going to file a declaration. I get a notice that yes, some declaration will be filed. I do not know the date on which you will file it. One. Secondly, I do not know the contents of that declaration that you will be filing. Nothing. That is the purpose of the second notice.
So the contents
Just
of the
because
declaration.
the first, rather it's the other way around. Mr. Kormokar, it may be also interpreted that first notice is as you are trying to interpret section 80, 10A1 notice is that a notice is circulated, majority come together, they want to make a declaration, right? Now they circulate a notice under Form E to the remaining owners to ascertain whether they also want to join. If they join, well and good. If they don't join, then these majority owners get to file the application all the same, declaration. When they file that declaration, the contents of that declaration, second notice is for the purpose of calling the people who are concerned. That is wider, not only the remaining owners, but if somebody else, suppose somebody else claims title who is not an owner, they get a notice because they will come and they'll know what is the content of the declaration. and they have an objection, right of objection on that content of the declaration. I will file a declaration. How do I know whether you'll show my flat? You can just get a declaration without disclosing my flat, my garage space.
Then the form will be defective.
We'll
Amendment
point
is
that out.
permissible.
That is the reason, Mr. Karmakar, for that inquiry. A notice is given.
Lord, for that inquiry, Lord, kindly sees what are required to be filed along with the declaration. Name of the owner, nature of interest of the property.
This is notice form E.
Section 10.
No, this is, you are speaking of form E.
Lord, Form E, your lordship has seen. Lord, Form E is basically a notice that this particular property is going for this, but Lord, submitted before the authority. That is Form E, nothing more than that. Lord, I am on Form A. A person who is seeing Form E has to be conscious of Form A. Now, Lord, Form A comes out of Lord, Section 10. The declaration referred to such and such, nature of interest of the such and such, existing encumbrance, description of each apartment containing its location actually built, description such and such, such and such. So, Lord, everything is given. Lord, what your lordship is saying, that say for example, there are 10 flats, I say 8 flats, other I don't show. In such a situation is taken care of. Lord, when I file, Lord, kindly sees what I am filing along with. 10A1. Any declaration referred to section 2 or any amendment thereto or instrument referred to in subsection 3.4 shall, for instance, be submitted by the sole owner of a majority such and such within 30 days from the date of its execution to the competent authority along with copies of site plans, building plans, and notice of intention to submit. So, Lord, there is no question of me withholding or tampering with any information. Similar, the person who is saying that I will not go for Form E, I will wait for the notice to come to me, and then I will go and say that my flat is not here. Lord, that is out of question, subject to correction. Lord,
there is no provision in the statute what those people, as you are saying,
my lord,
will have to introduce something into the statute to say that then these people who have notice under 10A1 will have to approach the competent authority. What will they approach on?
Yes.
Lord, does they have a notice that actually this declaration has been filed?
Lord, within that particular time, within this particular period, Lord, someone is going to file, and people who do not file, they have an opportunity also. Lord, kindly comes to
the second limb of 10A1. That itself gives the opportunity. Remaining owners shall be allowed to submit declaration subsequently. That is there.
That is there. The only purpose is not to stop the project to come within this act. The object is to bring in the project within this act. That is exactly what I shown from the statement of object. The sole object of this act is more and more projects should come within this ambit of this act.
You yourself said that the act has consciously kept it optional for people to come or go.
That's why optional. Else it was mandatory. Then there was no requirement
mandatory.
For
then
this.
it would be made mandatory in the act.
Lord, if
that was the intention, that it would be all purpose. It's the option of the owners.
Lord, option of the owners.
Majority owners. No, majority owners cannot trample the wishes of the others. At least they have a right to apply. If they validly apply, yes, they can get a declaration.
That notice is also there. Notice is Form E. Else, Lord, 10A2 Lord, would be rendered.
Form E is intention to submit property to the provisions. These are different things.
Even if Lord, the minority...
Mr. Karmakar, it is one thing to agree to the intention to submit. Yes, I agree. You submit form. No difficulty. But unless I get a notice of the... Because for the purpose of that inquiry, what is actually submitted? If that notice is not... Because what is 2? 2 says competent authority shall, after issuing notice to the parties concerned and after holding such inquiry,
yes,
as it may consider necessary, examine the declaration.
But if the competent
inquiry
authority wants,
contemplate others also.
But if the competent authority wants, there might not be any inquiry required also. That's why the word is used.
Yes, it was only after holding inquiry.
Yes.
Now issuing notice has been introduced.
Lord, why the parties concerned? Because the majority had to come in.
What the parties concerned then?
Parties concerned, Lord, I made that submission. Parties concerned have to be persons who have decided to submit before the jurisdiction.
That means the persons who apply, who file the declaration,
or
they will themselves.
subsequently they apply, or subsequently who wants to get in. They are parties concerned. Third party who sit back without doing anything, Lord, they cannot be parties concerned. Else this particular phrase was not required to be used. I have shown to your lordship, Lord, from the other portions and this
So
portion
then, according
also.
to you, the only the persons who seek declaration,
and
they are the parties concerned.
First, and the persons who subsequently come in by
Come
virtue of invitation through Form E or Milord 10A2.
How can they come? Come and do what? What is the provision for that?
But they apply for that. Milord 10.3, the later portion. No, this is not a. But grants me 1 minute's time, Lord.
So 3, you give an opportunity to any person aggrieved to file an appeal, and in the first place, no opportunity of no notice is given to him.
Not that.
I have a right of appeal, but I don't have a notice.
Lord, person aggrieved, Lord, includes everyone. That's why, Lord, again sees the difference in Lord the terminology used. Person aggrieved, not parties. Person aggrieved. That is one. The other aspect is, my lord,
as per your argument, Mr. Karmakar, where the statute wants, it has used owners, the expression owners. 2A deliberately does not use owners, but make it wider. Parties concerned. Parties concerned is definitely wider than owners. Owners are obviously concerned.
Lord, parties concerned.
Owners are a subset of parties concerned.
But perhaps it's different. Lord, just the reverse. Subject to Lord.
You say these parties means owners, and only the concerned owners will come.
Yes. Then
why not the owners concerned?
That's the reason why that has not been used. Owners.
Why
concerned,
not owners concerned?
Owners concerned are parties who have applied already, who are already there.
All right, very good.
But that's exactly why I have relied on the dictionary meaning of what is party and parties concerned. The other aspect, Lord, amendment. Lord, kindly comes to Lord the rule 3 and Milord 5 also, rather 5 in case of amendment. When rather 5, Milord, may I place 5 once, Milord? When in any circumstances stated in Rule 4, any amendment is made to the declaration submitted such and such by the sole, all or majority of owners of any property, such sole is such and such shall be submitted on Form A. Superscribed amended declaration. Lord, that's exactly what fell from your lordship. Lord, if certain portion are missed out or Lord, wrong declaration is given, in such a situation, the amendment is also there. And kindly sees here also, Lord, the conscious, at this stage, no adjudication is required any further because the property is already submitted. Here, Milord kindly sees everywhere sole owner, owners, the term owner has been used. In this entire bylaw, rule, act, the only place where your lordship would find this parties concerned Milord terminology is only 10A2. Nowhere else your lordship would find.
The same persons who filed the declaration, they can only file this amendment. Read it again.
My lord.
Not the others. When in any of the circumstances stated in Rule 4, any amendment is to be made in the declaration by sole, all or majority. Such sole, all or majority shall submit. The ones who originally submitted only they can.
Only those.
So I can amend my plaint.
So Milord, today,
the defendants.
So today, Milord, the minorities who did not participate
be shut out.
Despite Form E coming in, has to be shut out.
Every blood corpuscle of a judge gets annoyed when somebody says it has to be done. The minority has to be suppressed.
Lord, that is the purpose of Lord, the
Each and every
statement
molecule of a body of a judge, Mr. Kormakar,
starts
revolts
spoiling.
when we hear that minority has to be suppressed
That starts spoiling.
without giving an opportunity of hearing.
Lord, opportunity of hearing is
They don't get to have a copy of the declaration. They don't know what you are submitting. They have noticed that you intend to go and file a suit, file a declaration.
Form E. I go there, my lord. They have that notice. If they want to participate in that proceeding, they can very well go and approach, my lord, the authorities.
How do they know?
Lord, the form
Unless they get an issue of, they get a notice of hearing.
Form E একবার খুল।
They have to have a notice of hearing that I'll hear it on this date.
I'll form E একবার।
You, the proposed declarants, they give a notice that we intend to go and file. Then what will I do if I get the notice? Even if I get the notice, how do I know at which hour, on which date exactly you are going and filing that? And how do I get to know the complaints? Unless a further notice is given to me that yes, such declaration has been filed, this is the declaration, you come and we'll have a hearing. You say that yes, I intend to file a declaration. Very well, I know that I am the minority. What do I do then? I'll keep a vigil. I'll put a blanket beside the footpath of the olden days of that office, of the competent authorities office, and wait when he will come, and I'll go.
With respect to this, Lord, what objection can a person take in this?
So many.
Lord, what let the scope of inquiry has to also be
As many entries there are in the forms, that many objections can be taken.
Lord, with respect to this, these are matter of facts will be evident, which will be evident from the building plan itself.
It is for the inquiry to facilitate the inquiry, Mr. Kormakar, that the others are permitted to come and point out that see, these are the irregularities. It's like an adversarial system. Mr. I is the petitioner. He convinces me on whatever his arguments are. I hear one side, and I enter into an inquiry, but I miss out certain things. My inquiry does not reveal certain things. It's you who are there to point out those, that see, these things are also there. That is the reason of giving a hearing.
But
The
in
premise
such
of audio alternative party is that.
But in such a situation, Lord, then with respect to Lord, the statement of object and reasons, Lord, may I ask this
Not
question
a
to
civil
myself?
suit hearing.
May I
Only
ask-
on the points
Yes,
that
Lord.
show us that these are wrong.
May I ask this question to myself, Lord, in such a situation, what will be the requirement of that object which says, Lord, it's only to call out that minority?
No,
which
it's
did
not
not
to call out minority, Mr. It's the reverse. You are looking it from the converse perspective. It's not to suppress somebody. It's to give a right to certain other persons. It's not to suppress the minorities that this is being done. It is only for the purpose of carving out a right for the majority. What was happening was that unless each and every owner wants, it cannot be done. So the purpose of the act is being frustrated. Say, suppose there are 100, 99 one does not want. No, does not happen. That's why majority now may come. If there are 100 people, 51 may come and file that give a notice that we intend, and then other 40 may come in and join, and still there will be some remaining. Then what happens? These 90 people or these 70 people or those original 51 people go and file the declaration. Then what happens? A notice is given to the all persons concerned, whoever is concerned, so that they come and they may point out, because that notice is intertwined with the inquiry. See, the inquiry will be held upon giving notice.
But this party is concerned, Lord,
It's not to suppress their rights. It's yes, majority has a right, and still then, even if the minority come or some of them come and say that we have this objection, yes,
they will be heard.
After hearing them, it can be held all the same. That no, majority has a right, and if majority is correct, then it will be allowed. But so that majority cannot, do something which is beyond the law.
In such a situation, Lord, the expression ought to have been, Lord, as used elsewhere.
Statement of object and reason of 1992 amendment is entirely ocious, academic, because we are speaking of a 2015 amendment.
But 2015 amendment did not introduce, Lord, that notice of parties. Notice of parties.
It has to be now read in the light of 2015.
Yes, Lord, notice
2015
of party.
came in. 2015, when 2015 came in, Mr. Collins, because your argument is premised on 2015.
Yes.
Do you get what?
Yes.
Because your argument is based, your justification is by virtue of that e-form is being given. But 2015 came afterwards. So now we have to read to subsection 2 in the light of 2015.
But despite the 2015 Act coming in,
2015 Act coming in precisely, that was retained.
this particular portion was not amended.
That was retained. That is the reason.
Kindly-
If your intention was the intention of the legislature, the further notice would be just removed.
But that further notice was.
Why should the applicants get a further notice of what, Mr. Kormokar? I apply, I file the declaration. Why should a notice be given to me? Of what? Of what?
Then Form E's requirement was not.
In the first place,
I found out what is falling.
Why
from
should
your
I
lordship,
be
Lord.
given? I will be given a notice that yes, you have filed. That wouldn't that be absurd?
Then the expression should have been used.
Might have been whatever, but whatever, if that interpretation is given, it's as I said, the plaintiff being given a serves a summons of his own suit.
But because elsewhere.
See, you have filed a suit.
But because elsewhere also, Lord, in all other acts of state.
Forget
other
the
state-
jargon. Let us see the intention of the statute read in conjunction. One read in conjunction with two of 10.
But that has also to be, Lord, equated with all other Lord, statutes operating in different states in the same
See,
field.
state statutes are always unhappy in some manner or the other. Always. You cannot find 1997 Act came partially copy pasted.
But some
Still creasing, the creases are being
but
obliterated.
some parity has to be given, Lord, to the other statutes prevailing on the same subject in the same state.
It's
different
like the repair of roads before the puja. The current formulation of statute.
Lord, your
Just
lordship-
like that. You will see the CSC works on a portion, they do a patchwork. The level of the other portion of the road
KMC comes in.
KMC comes in, they dig it further, and then ultimately it's raised so high that entire water comes into your home.
Previously, BSNL also used to.
PSM will also now
it's not.
previously not now. Yes.
Now,
So
Lord,
that is what is happening to the statutes.
Lord,
15 comes, 2015. E-form comes in.
This
E-form
adjudication, what is falling from your lordship, Lord, is
2015 amendment retained. What is falling from me is 2015 Act came.
Yes.
Yes, there has to be a prior circulation of intention, that is to gather whether somebody else wants to join in. But still 2015 legislature in its wisdom retained to. If that was the scenario what we are arguing, you have a point in party that Black's law, it's an excellent argument, we'll have to consider. But yet the other aspect is this, that 2015, despite 2015 coming in and a prior notice being given, see, you can come and join. 2 is retained. Second notice is not erased,
Obliterated.
not omitted. It is still retained. Why is it still retained?
Because what I fell from, Lord, reading
Maybe the
other
legislature forgot,
Lord,
intended what you are saying.
Lord, other statutes also, Lord, in all other statutes,
All other each statute is on its own footing.
majority of the states, Lord, do not have this adjudication procedure. They have
That
done
we
away
cannot go by other states.
with, Lord, respect to, Lord, states.
Mr.
which
Kormkar,
have
that will
the
be a
clause.
bad comparison. Bad comparison. Every other legislature has its own things. We cannot draw a parity with others, what the others are doing.
Only West Bengal has this clause.
Only West Bengal has many things.
Has this clause.
Only West Bengal has Rahul Kormokar.
Lord,
Only West Bengal has many things. Like just like only Maharashtra has many things. So that's a different aspect altogether. We have to look into this statute as the law of West Bengal. We cannot draw parity with other states' legislations. Why should we? They have their different intentions. Their objectives may be dependent on their polity also.
a requirement.
Their
But this
requirement, their many things.
requirement of this apartment ownership remains the same for all.
General.
That I've checked up. That remains same
Yes,
for all.
that remains general.
The only requirement is not notice to be heard. That is the only requirement.
Some don't have, some have. What should be the conclusion?
Nobody has. Only this.
So
place-
then we are most egalitarian.
this state only has it.
That is what we are saying.
But
We
I
are the
have-
most egalitarian.
But perhaps not.
And we are the only state then, if you say so, who thinks that yes, the minorities should be heard.
Lord, minorities, yes, Lord, with respect to my submission, Lord.
Always for the,
Minorities.
not minority as in religion or language or something like that. Anywhere, wherever there is a minority, Mr. Kormokar, democracy requires their rights to be protected in any field. Anywhere. We are not talking about linguistics, religion. Those have become now political subjects. We are not on that. But anywhere where there is a minority, even one person, we have to protect the interest. At least has to have a right of hearing. After that, yes, you say no, the majority, maybe majority is mostly correct in so many cases.
But after the intervention of my lord's court, Lord, They have been heard on 3 occasions.
In this matter?
Yes, they have been heard on 3 occasions. Not repeatedly, it was sent back. They were heard. Their objections are assailed. They came up. But I'll indicate.
No, but it's a very good. Do this. Put your written notes of argument in form of writing, and we'll just take it. Because this will go on. Because we have understood. I have understood what you are saying. Both ways, I'll put my mind to both considerations. So, Mr. Karmakar, don't worry on that.
Considers that
Party and use of words is a very good argument. Yes. Rest of the statute use of words, this is absolutely in consonance with legal interpretation. What you are saying. Owner used in other parts, not used in this. Valid argument. Party definition. The moment you say party, you have to be party to something. Good argument. Valid argument. We will consider that. But I just put the other aspect to you so that you can answer. Yes, Mr. Rai. Put it in your written notes. Reiterating whatever you say.
Only 4-5 things, my lord, I want to submit. So far as
4-5 in 4-5 minutes.
4-5 minutes, because I don't have much time.
You have 4-5 minutes.
Yes. So far as the Form E is concerned, my lord, may I say, the Form E which was issued at 209 was itself a very defective one, because it has been issued by 5 individuals and countersigned by the Greenfield LLP, who was not a declarant in the main body of the Form E notice. It has to be issued by a majority members, but it has not been issued by a majority member.
Do you get anywhere the total number of members? Is it an admitted position?
Yes.
My lord, the thing
What is the total number?
the total
Approximately.
number we had indicated
In hundreds or
if you
tens or what?
kindly see for once 209. The statute clearly says 3(1)(a) that those majority persons who wants to declare or intend to declare the property, they have to issue Form E. They means the majority.
Yes.
They does not mean the single owner or all the owners. But majority owners need to.
In your case, what has been done?
5. Only 5.
What is the total?
Out of 3,000.
3,000?
Yes. 5.
Very well, yes.
Now, my Dada, আমি বলি আমার
No, he is not. Mr. Rai, he is not. Mr. Karmakar, poor Mr. Karmakar is doing his own thing.
The defect was from the very initiation that Form E notice, my lord, was not sent to anyone, because under Form A, it has been categorically stated that what are required to be annexed along with the Form A, which specifically states that there has to be receipts of Form E. There has to be receipts of
annexed with that.
Yes, that is there in the Form A. Or the documents which are required to be submitted along with that document.
Yeah, it was not done.
It was not done. It was not sent to anybody. Only 5%.
Next point, go to the next point, put it in a written.
Next point is this, my lord. So far as the completion certificate is concerned, the Act envisages only 2 certificates. First is the completion certificate and second one is the occupational certificate. The stand of my learned friend is this: the project is not yet complete, so completion certificate at present is not required. That if the completion certificate is awaited, it's still not there. Under this Act of 1972, they ought not to, could not have submitted the property at all. There has to be a completion certificate, or else this property cannot be submitted. And secondly, my lord, apart from the occupational certificate, the definition of competent authority, lordship, will kindly see for once. The competent authority says, who are the competent authorities? No. Definition.
Who has acted as a competent authority here?
Here, my lord, competent authority definition.
Yeah, what is your argument?
My argument is this one: apart from the competent authority means any person or any officer not below the rank of a deputy magistrate authorized by the state government by notification in the official gazette to perform functions of the competent authority under the Act for such area as may be specified in the notification, and different person, my lord, kindly mark this, and different person or officers may be authorized for different functions for different areas. Here, the competent authority is not the authority which is sitting in the new secretariat building, my lord. Here, the competent authority who will issue the completion certificate is the structural engineer and the surveyor as per building rule 16 of the municipal building rules. So, one way or the other, either the completion certificate stated there has to be construed as the completion certificate under this Act, or the occupational certificate under Rule 34 of the, my lord, kindly see the competent authority here, 16. The duties and responsibilities of architect and licensed building surveyor they shall submit the completion certificate and completion plan immediately after the work is completed. So here the structural engineer and the surveyor is the competent authority, and they have submitted the completion certificate, and that has to be construed as a completion certificate under this act, and time runs from the date of issuance. Now, if my learned friend's submission is to be considered, then he ought not to have submitted the entire property because it is still under construction. So under construction project was also submitted. And if I construe occupational certificate as a completion certificate, then also it is hopelessly time barred. Now, so far as, my lord, the submission of the form EA is concerned, the declaration is very clearly stated that at the first instance, my lord, kindly come to Rule 10A for once. Section 10A. Any declaration referred to in Section 2 or any amendment thereto or any instrument referred to in subsection 3 or 4 shall in the first instance be submitted by the sole owner or all the owners or the majority of the owners of the apartments in duplicate. Here, my lord, what they have done, my lord, neither they have submitted for me to anyone. An anonymous person on the basis of an application addressed to the competent authority issued that notice, and competent authority illegally took cognizance of the same. And kindly come to, my lord, the notice on the basis of which they have submitted, that is, I have annexed. Kindly see page 95 of my reply of 8125. Illegality, my lord, everywhere at every steps, non-compliance everywhere, every steps. Kindly see, my lord, page 95. Lordship was asking all the owners should be at least notified. Lordship, kindly see page 95, what they have done. An anonymous application as per their own affidavit. Page 95 of the reply to 8125. It is not issued to anybody. Annexure P11. Well, kindly see, this has been issued in respect of an application submitted by anonymous person before the competent authority when there was no such provision to that extent. Notice is hereby given to whom? I don't know, my lord. Nothing is written here. Of subsection 2 under West Bengal Apartment Ownership Act to the applicant to appear before the undersigned on 12/4/2022 along with declarants. When there were 5 individuals in notice in Form E, now it has been reduced to 2 declarants, whose declarants, my lord.
This in your written notes, I have understood. Yes.
And my lord, another aspect is.
What is that?
My lord, there, so far as they have once said that the power of attorney was used. My respectful submission is this, my lord, the relevant provision Rule 3(1), it says that everyone has to be present before the magistrate for affirmation. Everyone has to submit for the declaration, and within 30 days of execution, it has to be submitted before the authority. Not a single owner out of 3,000 flats, my lord, had submitted their or executed their property before the magistrate or affirmed their documents before the magistrate as required under section 10A2. Huh?
Under construction project, we have
And my lord, Form A under construction project has also been submitted. And in the declaration, my lord, it appears, and what you will find, that completion certificate they have.
So what have you challenged here in the writ petition?
Illegality in acceptance of Form A. Because of
that only. So we won't go into the merits of the Form A at this stage.
Another one.
Because you hit at the very root of the acceptance itself.
Yes. Only one thing, my lord. Form A was submitted on 12th of April 2022. No notice was given upon submission of declaration. No hearing, no inquiry, nothing was conducted. Same day it was approved. Same day it was approved, and it appears from their own affidavit. Lordship, kindly
refer to the affidavit page number in your.
Just a minute, Dada bhai, ektu dada.
No further. The file of written notes.
Page 89 of my reply.
Lord, I shall also use the list of date also. Lord, to show that Form A was submitted.
Whatever you exchange between yourselves, you have 2 weeks between yourselves.
My lord,
we'll come back on and take it up on 8th of August. You exchange between yourselves.
My lord, I say that as it is their affidavit, at page 89. My lord, kindly mark it. I say that as long back as 12th of April, a declaration as contemplated under section 10, read with section 10A of West Bengal Apartment Ownership Act was submitted before the competent authority. On receipt whereof an order was passed on 12th April accepting such declaration.
This is what? Their own
affidavit says that on the same day Form A was submitted.
You refer to this page in your written notes.
Yes, I have already referred to my page.
Written notes are ready?
Yes.
No, we wait for their written notes also. Let you give a copy of this to them and get their copy also. If you want to add something, you make the modifications and exchange and come back. I'll be coming back on 4th from Jalpaiguri. I'll be sitting next on 8th. 8th, I'll take up this matter.
So, my lord, I
For
can
written notes of
add
argument.
submission.
No further submission. Sir, enough of submissions on this.
I will be relying upon your lordship's order, which I have annexed in the...
That you can make further submissions.
No. On lordship holding that about the parties concerned. Illegalities at every step.
That is what we are trying to cut short because if you go on like this, we don't know when next we can reach this matter.
Another one submission, my lord.
Here are the submissions because it will be dealt with in your written notes. Yes. Take note of the submissions.
Acceptance of Form A is generally precedes by a reason. The Act says there has to be a reason in writing before acceptance of Form A. Here, no reasoning has been given.
Which section says that?
Yes, section 10A.
10 itself.
10A.
An order has to be passed.
10A.
Yes, right. After that inquiry.
Yes,
you're right.
There has to be a writing that why I am accepting.
Notice, inquiry, reason.
Yes. There has to be reasoning. No reasoning here.
It's there.
Only a seal that it has been approved. Even under construction property has also been submitted.
That you have said thrice.
Yes.
But write it in your written notes only once.
I have dealt everything, my lord.
No, keep retain that. I'll not take that on record because after getting their copy, you may have something more to add. So prepare between yourselves and come and file. Here, oral arguments are concluded. Full stop. Let the matter be listed on August 8, 2025 under the heading to be mentioned for the purpose of filing of written notes of arguments. So that you get precedence. First matter, file your written notes. Do other matters.